Good afternoon, and welcome to the Lansing Charter Commission first meeting. I will officially call the meeting to order. And I would note that under the Michigan Home Rule City Act, the city clerk presides at the first meeting of the Charter Commission. And then I will be the clerk of the commission for the duration of the commission's tenure. And so I will begin today by calling roll. Commissioner Anderson.
Here.
Commissioner Bauer.
Here.
Commissioner Boyd.
Here.
Commissioner Dowd.
Here.
Commissioner Jeffries.
Here.
Commissioner Lopez. Commissioner Quawi.
Present.
Commissioner Adam Simon.
Here.
Commissioner Washington.
Here.
There are 8 members present at quorum. Commissioner Lopez is absent. And now we will proceed to administering the oath of office to the commissioners. And we're going to do that individually down in the well. And we'll start on my right-hand side. So if you can step down, and then once you come back to your seat, you can sign both copies of the oath. We'll collect that, and once I sign it, there will be 1 copy for you. Okay? Let's start with you. Commissioner Boyd. Step right up to the mic.
Raise your right hand.
Raise your right hand and repeat after me. I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of Michigan,
and the Constitution of the State of Michigan,
and that I will faithfully discharge the duties
and that I will faithfully discharge the duties
of the office of Charter Commission member
of the office of Charter Commission member
according to the best of my ability.
according to the best of my ability.
Congratulations.
Thank you.
All right, come on, Commissioner Bauer. All right, now I need to raise it back up a little bit. There we go. Okay. Raise your right hand. I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of Michigan,
and the Constitution of the State of Michigan,
and that I will faithfully discharge the duties
and I will faithfully discharge the duties
of the office of Charter Commissioner
of the office of Charter Commissioner
according to the best of my ability.
according to the best of my abilities.
Congratulations.
Thank you.
Commissioner Anderson. All right, you can see how it's done. Raise your
Yes.
right hand. I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of Michigan,
and the Constitution of the State of Michigan,
and that I will faithfully discharge the duties
and that I will faithfully discharge the duties
of the office of Charter Commissioner
of the office of Charter Commissioner
according to the best of my ability.
according to the best of my ability.
Congratulations.
Thank you.
Let's do this.
All right, raise your right hand. I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of Michigan,
and the Constitution of the State of Michigan,
and that I will faithfully discharge the duties
and I will faithfully discharge the duties
of the office of Charter Commissioner
of the office of Charter Commissioner
according to the best of my ability.
according to the best of my abilities.
Congratulations. All right. Repeat after me. I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
I will support the Constitution of the United States
and the Constitution of the State of Michigan,
and the Constitution of the State of Michigan,
and I will faithfully discharge the duties
and I will faithfully discharge the duties
of the office of Charter Commissioner
of the office of Charter Commissioner
according to the best of my ability.
according to the best of my abilities.
Congratulations. raise this a little bit?
I don't know.
There we go. All right. I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of Michigan,
and the Constitution of the State of Michigan,
and that I will faithfully discharge the duties
and that I will faithfully discharge the duties
of the Office of Charter Commissioner
of the Office of Charter Commissioner
according to the best of my ability.
according to the best of my abilities.
Congratulations.
Thanks.
All right. I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of Michigan,
and the Constitution of the State of Michigan,
and that I will faithfully discharge the duties
and I will faithfully discharge the duties
of the Office of Charter Commissioner
of the Office of Charter Commissioner
according to the best of my ability.
according to the best of my ability. Thank you. Thanks.
You all are not sitting in height order, I can tell you that. All right.
Does that work?
I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of Michigan,
and the Constitution of the State of Michigan,
and that I will faithfully discharge the duties
and that I will faithfully discharge the duties
of the Office of Charter Commissioner
of the Office of Charter Commissioner
according to the best of my ability.
according to the best of my ability.
Congratulations.
Thank you.
All right. You ready?
Ready.
I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of Michigan,
and the Constitution of the State of Michigan.
and that I will faithfully discharge the duties
I will faithfully discharge the duties
of the Office of Charter Commissioner
of the Office of Charter Commissioner
according to the best of my ability.
according to the best of my ability.
Congratulations.
Thank you.
Okay. Well, now they are all sworn officers of the city, and congratulations all. Can I have a motion to adopt the agenda?
So moved.
Moved by Commissioner Adam Simon, supported by Commissioner Bauer, I saw first. Any discussion? All those in favor say aye. Aye. Any opposed? That motion carries. Okay, so we will move on to a presentation by the Michigan Municipal League. And so I will turn it over to Chris Johnson, who is here as their representative. And we have the materials will be on the screen. Did we print those out for the commissioners?
Yes, we do. Yep.
And those are printed out for you, so you'll be able to follow along and take notes. We'll turn it over to you.
Thank you. As they just mentioned, my name's Chris Johnson. I'm the General Counsel of the Michigan Municipal League. Prior to that, I was in my own law firm, practiced municipal law for about 35 years and have been General Counsel now for about 5 years since. In addition to that, I have a confession to make. I'm a recovering politician. I spent 28 years as mayor of my community, and prior to that, I spent 12 years on the school board. So I'm City of Northville. And it just proves I'm a glutton for punishment. But we do have a lot to cover tonight, so just wanted you to be aware of a little bit of my background. If we could tune in the slides. Okay, the one thing that is really clear is that local government is a creature of the state, so we're really subject to the whims of the state of Michigan and the legislature and the courts. Sometimes they pass a law that helps us, sometimes they pass a law that restricts us, and then the courts interpret it sometimes the way it was written and sometimes other ways. The first constitution in this state was in 1908 that gave us the concept of home rule. And that's a really important thing, and that's part of why we're here tonight. The current constitution in 1963 actually strengthened home rule for cities and villages in this state and really made a difference. Here's actual language of this section in the Constitution that gives us that home rule ability. I'm not going to read it to you. You can read it at your leisure, but it's a really important section that relates to all cities and villages in this state. The provisions of the Constitution really make sure that you understand this part of the Constitution because it becomes the bedrock of what we're doing. The Charter is essentially your Constitution. It's the thing that makes your, sets all the rules for the city and how you will govern the city. And your role as a Charter Commission is essentially to be that constitutional convention right here in the city of Lansing. There are a number of things that the Act says are mandatory in your charter. There are a number of things that are permissible in the charter, and there's a few things that are not acceptable in a charter, and we'll get to a few of those in a moment. Mandatory provisions. The election of the mayor or appointment is one of the things that's chief and foremost in the charter statute. The nominations of elected officers are also important in the charter. The time, manner, and holding of elections and the registration of electors are supposed to be in your charter. Some of the other mandatory provisions are the qualifications, duties of officers, the appointment of chief administrative officers such as city manager if you have one, the establishment of wards, and if there's one ward, for equal representation for each of the wards. So that's important as well. The subject of taxation for municipal purposes should be in there, as well as the fact that you'll be collecting taxes for all of the units of government, including the schools and the county and the state. The annual levy of property taxes, which cannot exceed 20 mills. So that's an important part of your charter. The appropriations of money for municipal purposes is really important. And finally, the handling of state, county, and school taxes, which is subject to the general laws of the state. The public peace, health, and safety of our residents is important. The requirements for adoption of city ordinances, including the publication of ordinances and penalties for violation of those ordinances, and the requirements for the city to follow the Open Meetings Act. And we're going to cover that in a little bit of detail later on. You're required to keep a journal in the English language. You can also keep them in other languages if you want, but it's mandatory that we do it in the English language. And finally, you need to adopt a system of accounts that's acceptable to the state pursuant to state law. Now, some of the customary items that you find in a city charter include the name of the city, the power to sue and be sued, the power to enter into contracts, the power to acquire and dispose of property, both real and personal, a requirement for officers to take an oath, which you just went through, and also for surety bonds if that position is needed. Other customary provisions include the power of eminent domain, the authorization of a municipal seal, also when there's a vacancy in the municipal office, how you will fill that vacancy. The boundaries of the city is usually on file with the Office of the Great Seal, and special meeting requirements should be in your charter as well. You're always subject, however, to the Open Meetings Act, and that's why we're going to spend a bit of time on the Open Meetings Act. Permissive provisions in a charter include things like water mains, sewers, waterworks, electric lighting, power utilities, public improvement costs and special assessments for them, as well as boulevard lighting systems. You can also do acquisition of private property, maintenance, development, operation, sale and lease and disposition of property, rapid transit, streets, alleys, including public ways. Parking is permitted. You can also regulate certain trades, occupations, or amusements, establish city departments within the charter. And by the way, that does not include the school systems. They're a separate level of government all by themselves, so you don't have any responsibility or control over city schools. You can designate civil infractions and blight violations. You can provide for medical facilities. Now, it's really important to understand your role on the Charter Commission. You want to be identifying community values that really need to address city government, and those should be contained in your charter. The new charter will have a lasting impact if you adopt a new one. So think long and hard about what you want to put in that charter. It's really important to do it correctly. You want to encourage public participation, and this is a great way to do it with a audience here, and also being on your local TV station. Proactively engaging religious, business, labor, and other communities, groups, and service clubs is also a good way to, get that input that you need from the local community. And as required by the Open Meetings Act, you will practice transparency. There are 9 members of this commission, and the Charter Commission has that 3-year term. You will be done in 3 years, whether you like it or not. That's your deadline. Charter can be presented to the electorate up to 3 times. And if you strike out 3 times, you're out. So you'll be done there too. You may meet up to 90 times with compensation, may meet more often without compensation, but you only can receive compensation for 1 meeting a day. That's within the state law. You really need to set some sort of time frame in your own minds. You want to do fact-finding and research, again, public outreach, input from city officials, employees, because they know what they're doing. They've been doing it for a while, and you should rely on that expertise. You'll have to do drafting. You'll have to do a review by the governor, and the governor will quickly shift it over to the Attorney General's office. And that's a necessary step as well. Finally, you'll do publication and a campaign and possible time for redrafting if the AG's office says, well, you can't do this and you can't do that, and you may want to take a look at this item and make that a little clearer. 18 months is often used as a kind of a rough timeline. I'm not saying you can or won't do it faster or shorter or longer, but kind of keep in mind that 18 months is usually typical throughout the state. That gives you 6 months for fact-finding and research, 8 months for drafting, which is actually a hard thing to do, 2 to 3 months for the AG review, and then finally 1 to 2 months for the final campaign and the election. Then, later in the process, we noticed that the AG returns the charter or proposed charter with a lot of comments and asks for some redrafting. You do not have to follow their suggestions, but they're usually grounded in some really important law that the Attorney General's office wants to call to your attention. And because of that, I would take note of what they're saying and why they're saying it. Again, you can take it to the voters without changing those things, but you might have legal challenges after you've adopted a new charter that has provisions in conflict with state law, for example. And actually, one of the sources I'm going to have you rely on is somebody in the AG's office so that you're not getting afoul of them in the first place. They're just down the street, so it's not like, somebody from the UP having to, go a long, far way to, get the AG's attention. If you're rejected by the electorate, you have the idea that you can just say, we're done, we gave it our best shot, or you can take another chance at trying to get it passed. As I mentioned before, you get 3 shots at it, so, take them if you want them to. Finally, what does it really mean? It really means cities can be very, very flexible. You're really limited by your imagination in the state law, but you can combine all sorts of things into your charter. You can pare it down to the way you want it to. You don't have to make it a really complicated document. And other than those mandatory provisions I talked about at the beginning, you don't have to have all that much in the charter either. So pick and choose, and it provides a real flexible document. And here are some resources I strongly recommend. We have a charter revision handbook that's available on our website, mml.org. Click on resources. We also have a research coordinator, Mary Charles, who's very good at knowing what charter provisions are in other communities throughout the state, both cities and villages. We have a charter database, so if you find out there's a city that has a particular provision that you really like, we can get you a copy of it. And the Model City Charter from the National Civic League is available to you as well if you want to review that. Some other resources is George Elworth. He's the person in the Attorney General's office that gets all the questions for charters throughout the state of Michigan. And he can be a real resource to you, and he's always happy to assist. Finally, there's the Citizens Research Council of Michigan, Wayne State University, University of Michigan, and Michigan State University are all have some experts in this area. And finally, there's a attorney publication from ICL, which is the continuing legal education for attorneys, and they have a chapter called Local Government Law and Practice, and there's a whole section, chapter in that book. It's a thick book, but there's a shorter chapter, and that's a resource you can use, and you can get that book from the ICL publications.
What is the name of that book again?
The name of the book is Local Government Law and Practice in Michigan. Looks like we got some of these out of order. Oh, can we switch now to the FOIA section? Excellent. I want to make sure you understand that everything you do in this commission is subject probably to a FOIA request. So you have to know what you're putting down on paper or putting in an email can have some real consequences. So we're going to check the policy of it, how to respond, who responds, and that sort of thing. To understand FOIA, I guess we got to go a little bit back into history. And the first federal FOIA was started in 1966. And President Johnson was really happy that there was actually a FOIA in there. However, there was a transition, and President Nixon came in, and we suffered a real scandal in 1974 with Watergate, and he was forced to resign, as a matter of fact. But there was a response here in Michigan, and that response was by the state legislature. And they passed 2 particular acts, the Freedom of Information Act of 1976 and the Open Meetings Act of 1976. Both were effective January 1, 1977. And by the way, I was on the school board when that happened, and it did change the way we did business. We couldn't go down to the bar and decide what we were going to do at the meeting later on. It just, no, can't do that. And a lot of people look at both of these
You
acts.
could drink, you just had to drink in person.
Yeah. And, you know, people looked at it two different ways, pleasant sunshine or it's really constraining. So I think you'll have to decide what you think of the act, but in any event, it's here to stay and we have it. The actual policy of the Freedom of Information Act, and I'll probably just call it FOIA from now on, is that people are entitled to full and complete information about how their government is working. So the court decisions are consistent since any cases come here with a FOIA matter. And that is that the people shall be informed so they may fully participate in the democratic process. So what does the public body need to provide? Well, it needs to provide a public record. And that is a writing that's prepared, owned, used, and in the possession or retained by the public body from the time it's created. And now we have to see what is a writing. Well, in 1976, they decided they wanted handwriting. Yeah, we did that. Typewriting, printing, photostatting. We don't really use that anymore. Photographing, photocopying, words, letters, pictures, sounds, symbols. But look at that last sentence, part of the sentence. Or other means of recording, retaining meaningful content. So they were kind of thinking this might change over time. And the reason why we have that broad definition of writing is this person. And that, if you don't know who she is, that's Rosemary Woods, who's the president's secretary, and that's the position she said she was in when she accidentally erased the 18 and a half minutes of the Watergate tape. And so what is the significance of that? Well, it means that a writing is more than just paper. It now includes, because of the way that the courts have interpreted FOIA, it includes texting, it includes email, it can include voicemail, it can include entries on a mobile data terminal. So all these things are now included within a FOIA request if they're ever made. Your responsibility as a public body is to appoint a FOIA coordinator, and that is usually done through the clerk's office. You individually do not respond to a FOIA request. That's not your job. Now, the FOIA coordinator may come to you and say, I need this, or I need that, or I need something else, but it's the FOIA coordinator that has the responsibility for actually responding to the FOIA request. So you need, as a city, to provide reasonable access and reasonable protection for your sensitive documents. The reason why this is true is there's only 5 business days to respond to a FOIA request. And if it's a large one, you get one additional 10-day extension. So that's a total of 15 days, business days, to respond, even if it's a mountain of stuff. So that's why when a FOIA request comes in, it's really important for that FOIA coordinator to get on it immediately. You don't, however, have to create a document or compile a document if it doesn't exist. So if somebody wants you to use you as a resource or research for them, you don't have to do that. You have to respond with documents that are already in existence. Let's go through a few common FOIA exceptions where you don't have to provide the information. Bids, for example. If I wanted to know what the bid was, I make a FOIA request and I'm going to come in $20 less than the bid of my friend that I just found out through a FOIA request. So you deny that. Test questions and answers. Boy, I would have loved to known what the questions and the answers were on my bar exam. That would have been fun. Made it a lot easier, but I couldn't get that. Tentative bargaining agreements, and I don't think you'll be involved with any of those negotiations. And also the Crime Victims' Rights Act actually provides a lot of new exceptions. You don't have to provide pictures of the ugly accident seen out on the expressway. A comma FOIA exception that may apply to you is if you have an attorney-client privilege document. And we're not talking about those situations where maybe somebody CCs the city attorney. What we're talking about is you have a legal problem, you ask the attorney for legal advice, and the attorney gives you legal advice. So that's a true attorney-client relationship, and those documents could be exempted if they're asked for under FOIA. Another one is invasion of privacy. Some things just don't provide the public with any knowledge about how government works or how your commission's going to operate. So those sorts of things will not necessarily be responded to in a FOIA request. Personnel records are generally FOIA-able, but certain parts of the personnel file are exempt. For example, social security numbers, banking information, counseling records, those types of matters still require a FOIA coordinator to go through the document and not just turn it over willy-nilly. Police records are generally exempt. Since you're not going to be dealing with police records, I'm kind of going to skip over this part. I want you to realize in 1976 that the idea that we could have a computer that actually would sit on your desk or on your lap, that was science fiction. And so was this. The closest thing we had to a cell phone back in those days was the communicators on Star Trek. They just didn't exist. Well, they were thinking of that sort of thing, but it was still science fiction. So please remember that even though this act was passed in 1976, we still have things that hadn't been invented yet, like email, text messages, and social media. Because of court decisions, all these things have been brought back into a FOIA request, potentially. So it's really important to understand, I always recommend to all my clients while I was actively practicing, and I still think it's a good idea, to assign an email number or email address to each one of you so that you can do all your city business on that particular email. And the reason why is if a FOIA request comes in, this FOIA coordinator can go to their own records and pull them out. If you're using your own phone or your own home computer, at some point you may have a circuit court judge say, turn it over and we're going to look through your hard drive. So please be cautious in that respect. A significant decision really in FOIA is this case called Howell Education Association versus the Board of Education. And the reason why this case is important is because it was a case where some citizen in Howell decided, I'm going to ask for every email in the Howell Board of Education system, every email. And the school board attorney at that time went through all the exceptions in FOIA and couldn't find any that really made sense. So they told the union, we're going to send this all over to the FOIA requester unless you get a court order that says we don't have to. So the school district was sued by the union to prevent all this stuff from going out. And the court came up with a concept known as purely personal communication. And by that, I meant things like, the meeting's running late, can you pick up Junior from daycare? Or, I really need a drink after this meeting. It was a long one. Or, would you please stop at the store for bread and milk before you get home, to a spouse. These things were deemed personal communications and had nothing to do with how the school district was run. In addition, the school district and the union had been communicating via this email on things like grievances and things like negotiations. And the court in that case even ruled that negotiations and grievance matters were purely personal communication, and then said, you don't get any of this. But I think the most important part of the case is that it's the content of the message. Does it relate to your job as a commissioner? And if it does, that means it's potentially subject to a FOIA request. You communicate with a citizen or you communicate with each other. That sort of thing could be considered a FOIA-able request, even if the only place it's on is your phone. So keep that in mind as you start, sending out messages, and who you send them out to makes a real difference. We have a lot of material on our website on FOIA, so I've given you a couple of resource areas that you can go to. That Michigan Municipal Law item, that big thick book I talked about before, does have a chapter on the sunshine laws, which includes both FOIA and it includes the Open Meetings Act. Okay, now for the fun stuff, the Open Meetings Act. Whatever you do in your charter, you're going to have to include the Open Meetings Act in your charter. It's required by state law, and you are subject to the Open Meetings Act. Again, we'll go through some of the policies, some of the basics, and some of the problems presented by COVID, which I think illustrate how courts get involved with what we do here at a local level. Again, we got here because of Watergate, and look at what this language actually says. A public body means, and including a board, commission, committee, and subcommittee. I think a lot of folks really got off on the wrong foot when they didn't realize subcommittee is subject to FOIA. And you can have a subcommittee of 2 people. We're going to send this particular thing off to a subcommittee. That's fine. But that subcommittee is still part and subject to an Open Meetings Act. Municipal attorneys at the very beginning of this really got off on, there's not a quorum of the group, so we don't have to worry about it. Well, the Supreme Court has taken care of that and says subcommittees included. The policy, again, of the Act is to make sure citizens have the right to know everything that's going on in their government. So that means unless there's a specific exemption in the statute, you can't go into a closed session. And look at this language that you see from the court in this case. We do not countenance the use of strained legalisms or evasions to undermine the intent of the Open Meetings Act. I mean, these folks come down hard on local governments when you're trying to evade the act. So, unless there is an exception, you shall do all your meetings in public, just like we're doing right now. However, even if you can go into closed session to discuss something that's subject to the exceptions in the Open Meetings Act, you still have to come out here and make your final decisions in public. So the Open Meetings Act really applies if you have a public body, and it includes your committees and subcommittees, meets with a quorum present or constructive quorum, and we'll talk about that in a moment, reconvene for the purpose of deliberating toward or rendering a decision, and something which requires a vote by the public body to implement public policy. So a meeting deliberation is defined as the careful discussion toward a decision. It can be carefully considering your options. It could be throwing all the options out on the table. It could be narrowing down your options. But that's deliberation, and the courts have made it really clear that those kinds of meetings still need to be in public. Again, we had a situation where it was at the University of Michigan. The regents broke themselves up into these little groups of 3. And then one regent walked around, again, not having a full quorum, thinking they could evade the Open Meetings Act by meeting this group and then this group and then this group over here. Well, the Supreme Court said no, that's a constructive quorum and you're doing it simply to evade the Open Meetings Act, and we're not going to tolerate that. And here's a thing that I think I want you to be very aware of too, and that's one-on-one conversations with each other. Probably the most important case in this one is St. Aubin versus Ishpeming City Council. And I've given you the citation there. While my name isn't on the particular case, because I was substituting in for another attorney in my firm, I actually got to argue this case. It was interesting because the presiding judge of this particular group was Judge Richard Griffin. And if you don't know who he is, he's the son of Senator Robert Griffin. And Senator Griffin was the minority whip in the state or the U.S. Senate. And his job was to call people up on the phone and say, how are you going to vote on this? So that they would know, what they're doing and why. So the mayor in that particular community had a lot of one-on-one phone calls with all of the council members. There were 4 other council members besides himself, and wanted to know what he thought of the city manager's performance. Well, the court in St. Aubin said that's okay. You can have those one-on-one conversations. That doesn't violate the Open Meetings Act. However, on the day of the next meeting, half hour before the meeting, all 5 of the city council members show up in the office of the city manager and basically say, either resign or we're going to fire you at the meeting. And that's where the city lost the case, because they all got together outside of a public meeting to do their actual business. And the court said that was a violation of the Open Meetings Act. So I won a battle, but I lost the war. And, you just don't do that. So you can have a conversation one-on-one. Don't get on a group phone call because that will violate the Open Meetings Act. But you can have individual conversations with each other. Open Meetings Act requires notice and minutes. Regular meetings have to be posted within 10 days of actually adopting your schedule of meetings. And you'll be doing that probably today, I think. Yes, you will be. So the other things you have to understand is if you change that meeting schedule, you have to post at least within 3 days after that. And Chris knows all about that stuff because that's his job. Special meetings or rescheduled meetings under the Open Meetings Act require at least 18 hours notice. And seriously, you have to do that with 18 hours notice. Don't try and cut that. I've had circuit judges lean over the bench and go, can't your clients count to 18, Mr. Johnson? Literally, I've had that happen to me, so it happens. And by the way, since you have such a good website, you need to post all your notices on the website as well, which I'm sure Chris is very aware of. You need to keep meeting minutes, which is important. Now, all the things I've listed here on this slide need to be in your minutes. You need the date, the time, the place, the members that are present, the members that are absent, the decisions that you make, the purpose of closing or calling any closed session, all roll call votes that are taken. And that's very important because that's what is required for minutes under the Open Meetings Act. When I became mayor in my community, I noticed they were taking minutes like a court transcript. And that's not the purpose of that. And as a lawyer, I love court transcripts, don't get me wrong. But we had one particular individual who loved to see his words in print and would talk accordingly so he could get more words in print. And then the poor city council, he'd say during the meeting to approve those minutes, he'd go, I didn't say that. And even me as a member of the audience looking in could see, yes, he did say that. And they'd have a 15-minute debate about whether he said it or not. You don't need a court transcript. If you do, you're going to get involved with, the minutia that shouldn't be there. So these are the things that you should have in your minutes. Public comment. Public has a right to comment. They have the right to video or tape it. I'm sure they're recording this today on your TV station. You can establish reasonable rules for that public comment. But you have to remember that a person can only be removed for a breach of the peace at the meeting. So assume Chris Johnson comes to your meeting. I'm raising holy heck. I'm being loud, obstreperous. You can say, Mr. Police Chief, would you escort Mr. Johnson out the door? And I get escorted out the door. But what happens when I come to your next meeting? You want me gone before I start. Wrong. You still have to let me misbehave a second time. As soon as I start misbehaving again, out the door. That's fine. But it's really important you understand that you can only remove a person for causing a breach of the peace at that meeting. The public body, and that includes your commission, can pick a time for public comment within the agenda itself. It can be at the beginning of the meeting. It could be during the meeting to address particular agenda topics. It can be at the end of the meeting. I suggest it's not a good idea to do it at the end of your business meeting because you've already made all the decisions. So you want to hear from the public. It's a real important thing. Second, you can set a time limit for people to talk, 2, 3, however many minutes you want to have. And if you can't say it within that time period, you're probably free-flowing rather than having a point that you really want to get across to the commission. But you can't set a total time limit on public comment, which is kind of interesting. Quite frankly, I used to use a technique in my community. If we had 50 people show up at a meeting, we knew we'd done something. And people were unhappy about it, and we were going to hear about it. So citizen 1 gets up and says A, B, C, and D. Citizen 2 gets up and says A, B, C, and D. Citizen 3 gets up and says A, B, C, and D. And guess what? I'm an active listener. So I'm noticing a pattern. They want us to do A, B, C, and D. So what we do then is I'll ask the person last up on the podium to say, Mr. Smith, you want the city council to do A, B, C, and D, correct? Yeah, that's it, Mayor. That's what I want. Okay. Now, who in the room agrees with Mr. Smith? Raise your hand. It's amazing. 45 hands will shoot right up out of those 50 people that are sitting there. Now, they've just told you what they were thinking because they all agreed with A, B, C, and D. And then it relieves them of that dread of having to go up at the podium and read A, B, C, and D at you for the 4th, 5th, 6th, 7th time. Now, if they want to still go up and do that, they may. And you can hold them to their time limit. But it really cuts down on the number of times you have to listen to the same thing. And people have spoken. It doesn't require you to do it necessarily. You still have to use your own independent judgment. However, you do have that ability to cut down on the number of folks that have gone to the podium. So, if you're going to have a closed session, there first has to be an open meeting. You always start with an open meeting. Always, always, always. And then there's a motion to go into closed session, a second, and the adoption of the motion to go into closed session. Please realize that there are 6 reasons under the Open Meetings Act that I think apply to public bodies. There's a lot of other exceptions, legislative exceptions, certain specific exemptions for certain specific things. There are generally 6 items that you'll be dealing with. The first is discipline and personnel evaluation. You only need a majority vote to go into that session, or collective bargaining, and you're not going to do any collective bargaining, so you won't worry about that one. I still recommend, even in those situations, that you do a roll call vote. It's like muscle memory. So if you always do it with the most restrictive way, which is roll call vote, you won't make a mistake and not do the roll call vote on some of the other ones. Now, I want to make sure, and again, Chris knows this, whatever reason you're going into closed session for, you put it in the minutes as well. I actually my firm represented a client that didn't put that little section into the minutes, and the circuit court judge reversed what they did, just because everybody knew they were going into closed session for a particular reason, but they didn't put it in the minutes. So that always goes in the minutes. Now I'm going to go through these 6 in order of the statute, not in order of their importance. And the first reason you can do is if you're hearing complaints against a named person and that named person requests a closed hearing. I always recommend that you get that in writing, because if I have a little piece of paper I can hand to the judge that says, John Smith signed this, I'm going to win that portion of the case. The second reason you can go into closed session is strategy on negotiations, and again, you won't be doing any collective bargaining agreement, so we'll skip that one. I don't think you will be purchasing or leasing real estate, so we'll skip that one. And you may go into closed session to consult with an attorney if you are subject to litigation and want to find out trial or settlement strategy on that specific litigation. The 5th reason is to consider applications for employment if the person requests anonymity and confidentiality. The reason why, unfortunately, is because there's some communities out there that as soon as they hear that Chris Johnson was applying for a job over in a neighboring community or across the state, they fire him. Just out and out fire him. Even though the person was looking to make more money, possibly have more responsibility in their job. But there's no recourse once these folks have been fired. However, if you do get to a point where you're interviewing somebody for that employment, the interview has to be done in public. So at that point, you'll have to disclose the resume and the application. And the last reason you can go into closed session is to review any material that's exempt under federal or state statute. I always talk about this in terms of city council. You may want to know what the plan would be for responding to a shooter at the high school. The city council can go into closed session to discuss that with the chief, because you don't want the bad guys to know how they're going to respond to a situation that's going to be life or death at the high school. So any reason that you will be discussing information that's confidential under state or federal law, you can go into closed session. A typical one, quite frankly, is if you are consulting with your attorney on something here for your commission and you want to get the straight legal advice from your attorney, you can bring the attorney in for a closed session. So you have to keep a separate set of minutes for the closed session. And those minutes are only disclosable if a circuit court judge orders it. You just don't turn over closed minutes of a city or a commission meeting. And it's interesting, so if you decide you're going to do those court transcript style minutes in closed sessions, and you want to go argue about whether somebody said that or not, you can go into closed session to review those minutes. Those minutes can be destroyed one day and 1 year after they're adopted by the public body. And remember that if you're in a closed session, the closed sessions are confidential. You don't walk out and tell people what happened in that closed session. It's confidential. It was closed for a reason. And there's actually an attorney general's opinion out there that said if you release the minutes, you're subject to possible civil and criminal sanctions. So be aware of that. Don't disclose those. And a lot of municipal attorneys, including myself, believe that you also can't discuss what was talked about as well as the minutes themselves. So there's a reason for going to closed session. The confidentiality of that information is important, and it's important for you as an individual commissioner to keep that information confidential. It also can be a violation of a number of these things. including whether or not you have ordinances on that. And Chris, I haven't gone through your ordinance book to know whether you specifically prevent that, but it's just not a good idea to violate that confidentiality. So here's kind of what's happened in the meantime. Technology, again, has come up with this. And I kind of liken this slide to a terrible crash in the middle of the picture there. And that's our state legislature over there on the right. And they haven't really amended the Open Meetings Act to take into account the changes that have happened with technology. And quite frankly, again, we have a technology trap. We've got these computers that are sitting on our desks or our laps or wherever. We have these phones that can transmit information back and forth. Think about it for a moment. There's more computing power in this handheld device than landed on the moon in 1969 and the computers they had in those days. It's amazing. So, deliberating can also happen electronically. And let me give you a couple examples. Both texting and emails can be a violation of the Open Meetings Act. Let's say we have a city council member who comes up with a great idea, and the council member shares that great idea with all the other council members by way of an email. That is not a violation of the Open Meetings Act. But we've all been trained in business to hit reply all. And the reason for that is everybody wants to know what everybody else is thinking, so there's no surprises. And in business, that's perfectly fine. But do you see the problem when you're doing it on an email instead of at an open meeting? That becomes a problem for you. The next one could be social media. We didn't have social media in 1976. Thank God. It made my job a lot easier. So assume council member one of a 5-person council takes to her Facebook page and shouts out this new great idea. And assume whatever the great new idea is relates to their position on the city council. Council member 2 does not like this great idea and puts a post of her own on there. And council member 3 agrees with council member 1 and posts a reply. It's all on Facebook. Maybe it's open to everybody. Maybe it's not. Maybe it's a private group. But do you see the problem? You have a majority of the council now not doing a one-on-one conversation, but you're involving the whole council or your whole commission in a situation where you're deliberating about what's going on. And you might have a circuit court judge that takes you to task on that. Again, what's a problem in both that email situation and the social media posting is that you don't follow any of the requirements of the Open Meetings Act. You haven't provided any notice. You haven't provided any citizen comment. You just haven't provided any of that. You're not taking minutes, although an email chain is probably a deadly thing in court anyway. So what happens? Well, these folks, the Attorney General, the county prosecutor, or actually any person, and that includes the media, can bring an action in civil court or circuit court to challenge the validity of the action that you've taken. So the circuit court judge might just throw out whatever you did, and you'll have to start over. Here's where I think it's really important to understand. The Open Meetings Act has criminal penalties in it for intentional violations of the Open Meetings Act. So my advice is always very cautious and conservative when it comes to the Open Meetings Act, because there's 90 days in jail and $1,000 for the first offense, and up to a year in jail and $2,000 for the second offense. That isn't fun anymore. And you didn't run for this position to intentionally violate the Open Meetings Act. And now we have an Attorney General that's done something that's never been done since 1976. And that was, she promised that if she finds out about a violation of a local public body, her office will do an investigation, a criminal investigation too, if it's warranted. So be careful, because for the first time ever since '76, we have an AG that promises to back that up. I'm going to use this COVID-19 example kind of as something to maybe understand how our courts get involved with interpreting things. We had the pandemic that resulted in several executive orders by the governor. There were a string of lawsuits that challenged the scope of the governor's authority on that. And she was using two particular provisions, the Emergency Powers of the Governor's Act and the State Emergency Management Act. These acts were passed in 46 and 76 of the last century. The court ruled that the 76 Act required the legislature to extend the emergency beyond 28 days. And while they did in this case for a few days, they didn't do it indefinitely like the governor had asked. The court also ruled that the 1946 law was unconstitutional because it gave too much legislative power to the governor. So now you have the two reasons that the governor was relying on as being undermined by the Supreme Court. It's really important then to note that after that decision came down, the legislature and the governor did agree on some amendments to the Open Meetings Act, which specifically provided for virtual meetings. And those virtual meetings could happen under a set of very strict circumstances, and the public body had to abide by each one of those rules. However, those portions of the Open Meetings Act expired as of December 31, 2021. So all your meetings now have to be in public at a place where you're all physically together. And if you attend virtually or remotely, you can listen, maybe even participate in it, but you do not count toward a quorum and you cannot vote. So those two things are definitely in place right now. Actually, the Michigan Municipal League would like to see some amendments in that so that people can participate even if they don't want to get somebody sick. I might have a cold or something that I can transmit to you, and I don't want that to happen. We're trying to get that amended, but legislature apparently wants you to be yelled at in public, or whatever that's worth. And my first rule of public service, especially as it relates to the Open Meetings Act, is it's not fun if you're sitting in jail. Again, you didn't run for this office to violate the Open Meetings Act, so pay careful attention to it. I think you'll be in good stead. Any questions on any of that? And we've given you copies of all the slides so that you can, look up any of the information you want on your, for yourself. And we also have a robust website where you can get a lot of resources on that website. So at this point, I'm going to call up Bob Slattery, and he will give you a dose of parliamentary procedure.
We are moving along a lot faster than than promised. So, if you can sit up there, that'd be great. Okay. And the clicker should be there.
I'm going to read all these books to you tonight. I think you'll enjoy that. No, I won't do that. I won't do that. So, I'm going to talk a bit tonight about parliamentary procedure. Chris talked to you about what your role is as Charter Commission members. He hopefully gave you some information about how to stay out of jail, yes?
Would you tell us your name and your title?
Oh, I'll get to that.
Okay.
Yes, I will. Thank you, Commissioner Boyd. My name is Bob Slattery. I was formerly the mayor of the city of Mount Morris for 19 years, and I'm a past president of the Michigan Municipal League. My day job for the last 30-some years has been in public service, mostly as planning directors for road commissions, first Oakland County, then Genesee County. And my last job was as the DPW director at the city of Burton. but I'm a student of parliamentary procedure. I've been studying parliamentary procedure under Coco Seward, who I'm sure some of you know, who was the parliamentarian at the Michigan Municipal League for many years. I've given presentations to local school boards in Genesee County. I've given presentations around the state for the Michigan Municipal League on parliamentary procedure and Robert's Rules of Order, and I'm a newly ordained registered parliamentarian. So, there. But as we go along, if you have questions, feel free to ask them. I know that I have several former commissioners here or council members here. I have CEOs of economic development corporations. I've got school board members. I've got some pretty well-read, well-rounded individuals here. So I'm going to try to keep things moving tonight. I'm not assuming that everybody is born knowing Robert's Rules of Order and parliamentary procedure. So we're going to kind of start from the beginning a little bit and hopefully go through things quickly and give you an overview. Where most of our time will be spent talking about various motions, because that's where the work gets done in parliamentary procedure. So if we could bring up, okay, there we go. Do I have a remote here? Is this my remote? All right. The green button. Oh, like that. Okay. And the back button is that. Okay, we're going to have a short agenda. We'll talk about parliamentary procedure, what it is. We'll talk about decorum. That's really important in any public body. And we're going to get into a little bit about civility as an offshoot of decorum. Robert defines decorum quite specifically. Civility is a little broader and also very important. Most of our time, I think, is going to be talking about various motions. We'll have examples of some of the various motions that you will find very useful as you conduct your meetings. And then a little bit at the end about various ways of voting. Da-da-da-da, one way. So parliamentary procedure is the accepted rules, ethics, and customs. It's things, the practices that you follow typically anyway in a meeting, whether you call it parliamentary procedure or not. But the parliamentary procedure that I'm going to talk about specifically applies to groups called deliberative assemblies, like this group. Groups that come together to make decisions. Autonomous bodies who make rules for themselves and where members have specific rights. All members of this group have a right to attend meetings. You have a right to voice your opinion or debate. You have a right to vote. And you have a right to make those very important motions that we talked about. Parliamentary procedure is based on common parliamentary law. And what that is basically the things that you do anyway in a meeting, in a polite meeting. You know that it takes a certain number of people to take action. It's called a quorum in Robert's, in parliamentary parlance. Only one person speaks at a time, and you only talk about one thing at a time. Now, in any meeting, or according to parliamentary procedure, you might have more than one question pending at a time. For example, and we'll get to this in a minute, somebody might make a motion that we do such and such. And while you're debating that, somebody else might say, well, I move that we amend that. So now you got two questions pending. And you deal with them in order. First, you deal with the amendment, and then you deal with the amended main motion. If the amendment is passed. If not, you deal with the main motion as it was originally. One question at a time, although you may have several stacked up. Decisions are made by the members who are present when the vote is taken. There's no consideration or a provision for proxy in Robert's Rules of Order or in parliamentary procedure. One member, one vote. You might be chairman of the program committee and you might also be treasurer, but you don't get two votes. You get one vote. The rights of the minority are protected because everything takes at least a majority vote to pass, and some things take a supermajority or a two-thirds vote. But everybody gets a chance to talk, and so the minority has a chance to make their viewpoint become that of the majority. And ultimately, majority rules. But even after majority rules, it's the group who is the final authority on whether the rules are being followed properly or not. The group is the ultimate authority in any deliberative assembly. So why use Robert's Rules of Order? I'm going to call it parliamentary procedure for now. Why use parliamentary procedure? Because it provides a recognizable format. Imagine if you had to learn one set of rules for the meetings you're going to have as your charter commission, and another set of rules for the school board, and another set of rules for city council. It's just a recognizable format. Helps to maintain order when only one person's speaking at a time. When everybody is making their comments through the chair, even if you want to talk to each other, you address your comments through the chair. That helps maintain order. Work is done by way of motions, and a motion is a way you bring up business before the body. I move that, or I make a motion that we do such and such. And those motions lead to decision making. They require a second, they require discussion, and a vote. Those decisions are recorded in minutes. And as Chris said, you don't need a court transcript. Your minutes should be a record of what was decided, the actions that you took. That helps expedite business and more quickly accomplish your goals. So where did all this come from? Well, some of it can be traced back to ancient Greeks and Thucydides and the Peloponnesian War and all that. But most of parliamentary procedure, as the name sort of implies, was evolved over centuries of trial and error and workings through the English Parliament. Over centuries. And then it came to this country as the colonists came over, but it came in various shapes and flavors depending on where those colonists came from and what rules they had set for themselves back in England. But they were effective enough that they were able to pass the Articles of Confederation in a loosely strung along group of colonies along the eastern seaboard, pass the declare independence, wage war, adopt a constitution, and start forming states throughout the eastern part of this country. All on procedures, ironically enough, I think, that they learned from Parliament. So we were able to free ourselves from Parliament with rules that we adopted from Parliament. But the parliamentary procedure that they use in the State House, that they used in the great assemblies, isn't exactly fit for use in a small body like this or in our local communities. Even today, the state legislatures use a different set of bodies. They use a different flavor of parliamentary procedure than Robert's Rules of Order. They don't use Robert's Rules of Order. But there really was a Robert, Henry Martin Robert. He was asked in 1863 to attend a church meeting. He didn't want to go. He didn't know anything about how to conduct a meeting, but he was a good soldier and he didn't want to decline, so he went. And they don't say too much about how that meeting went except to describe it as turbulent and that it lasted 14 hours. And Robert said, I'm not going to another meeting until I'm not even going to attend until I know something about procedure, parliamentary procedure as it pertains to these small groups. So he set out to do something about that. And he looked around. There were other parliamentary authorities at the time. This is the one on the left, Thomas Jefferson, the vice president, who was president of the Senate by that virtue, adopted a book for use in the Senate. And a guy named Cushing developed another book, different book of rules for use in the House of Representatives. All right? So there's at least two, and then every little group that Robert was associated with, and he and his wife were associated with lots of different little municipal groups, civic groups. They all had slightly different. So he started pulling all this stuff together. And then he put together ultimately his work, and let's see, it's not going to show up because they're overlapped on these slides. But there's a nice little pocket book that he developed called let's go back a slide. How do I do that? Okay. He called it a pocket manual of rules of order of deliberative assembly. The publisher wisely just called it Robert's Rules of Order. And it's come through 12 editions now, Robert's Rules of Order, newly revised, but note on the bottom there, Henry M. Robert III. Every revision, every edition that's come through have been through his successors and the copyright holders through his success, however that works, succession of copyright. Of course, now copyrights run out. And there's a lot of books out there that you'll see that says Robert's Rules on it, or Robert's Rules of Order. This is and it looks like this, 600 and some pages instead of the 100 and some that he envisioned. 600 and some pages. It covers every rule that possibly could come up in meetings, conventions, and delegations, voting, elections. They're all in here. And it's constantly being revised electronically through the website, through their national websites. But that's the edition you want to get, this one, Robert's Rules of Order, and you can get it as an audio book. It's great as an audio book. You can get it as a electronic book. I recommend the electronic version because you can look up things, you can search, and you can find certain. It's really good as an electronic book as a reference. Okay. There are others, okay. Mason's Manual still today is used by the state houses across the country. They don't use Robert's Rules of Order, they use Mason's Manual. And my favorite is this one, and it's not really a parliamentary authority. It's a book about a parliamentary authority. It's called Robert's Rules for Dummies. And if you can get past the title, and it's really a good place to start if you want to know something about parliamentary procedure. It's written in the whole, the dummy style. It's easy to look through. It's easy to look up stuff. And it references the 12th edition. But more seriously, this is the book you should get to know. Robert's Rules of Order in brief, because this is the one that cuts through the chase of all this stuff that we don't really need to conduct a meeting. This is how to conduct a meeting. This is a book, Robert's Rules of Order, newly revised in brief. It's meant to go along with Robert's Rules of Order, and it's written by the same folks that brought you the full cookbook. Okay? Good book. You should have that somebody here should have that on your desk, at least this one. Probably right on top of the big thick one that you're not going to read anyway. Actually, this one isn't bad to read. The big book, it's a reference book, and it's well laid out as a reference book because Robert was an engineer. But it's really not bad to read when you get into reading about a particular topic that you happen to have to be interested in at the moment. In the first 100 and some pages are history, which I just went over in 15 seconds. It's really interesting. All right, you operate as a charter commission under a funnel of laws, the U.S. Constitution, and then Chris mentioned the Michigan Constitution, Section 7, Article 22, or vice versa, I can never remember. Then you operate under the Home Rule Cities Act. City of Lansing is a home rule city. That allows you to adopt a charter, which you're going to do. In that charter will give you the authority to adopt ordinances and resolutions, and one of which will be the authority to adopt your own rules of procedure for your city council, which will supersede Robert's Rules of Order. So, for example, Robert says that everybody can talk 10 minutes on any subject, up to 2 times on any motion, on any day, on any subject. 10 minutes. You want to have, probably, a lot of people do, a rule of procedure that says we can talk 3 minutes. Okay? And you can do all kinds of things in your own rules of procedure that make things a lot easier than Robert's. There's a word I'm looking for, can't find it. Makes you conform Roberts to better fit you. Standing rules deal with your own administration stuff, and then custom. For example, it might be that the mayor pro tem makes a coffee before every meeting or something. A custom, whatever your custom is, or that you have to reimburse the treasurer for postage, or all those other things supersede Roberts except standing rules and custom. So if you have any rule, any of the things I'm going to talk about tonight, if you develop a rule to the contrary, your rule takes precedence to Roberts. Okay. Moving along. Standard order of business, or you're going to have an agenda that basically consists of, after you call it to order, you approve your minutes, you do reports. Well, you approve the minutes first to talk about what you did last time and make sure everybody's in agreement with that. Then you go on to reports. Unfinished business, there's no such thing as old business, by the way. There's a common misunderstanding that groups call it old business. Is there any, and the mayor or the chairman will say, is there any old business? First of all, the chairman should know if there's any unfinished business. And the unfinished business is very specifically things that you didn't get finished at the last meeting that were pending, things that were on the agenda the last meeting that you didn't get to. That's unfinished business. It's not old business where you can just bring up old stuff that you've talked about for 6 months and isn't going anywhere. Okay, then you get to new business, announcements, and a program if you have it, and then everybody's favorite, adjournment. Okay. Now, these agendas can take all kinds of form, from very simple 1, 2, 3 to more detailed where you actually list the times. But if you actually list the times, be guided by those times. It's very frustrating for members of your audience and even for other members to say, this is going to take place from 7:15 to 7:30, and then at 7:45, you're still doing it. Or it's 7 o'clock and you've already got to it. You know what I mean? You've already covered it. So if you got times, be guided by the times. The one on the right there, again, it's layered in such a way you can't see what that was, but that's the agenda for the city of Romulus. It's your typical agenda, but this is what's on the flip side, and I like it a lot. On the flip side of every one of their agendas that people will pick up as they come in is the rules regarding public addressing the city council or your charter commission. So it says you got to maintain decorum, you get 3 minutes, you get et cetera. You have to maybe fill out the paper ahead of time, whatever it is. But I like that idea, so everybody knows what the rules are. All right, so the agenda sets the time. If its times are there, be guided by the times. But if it's a public hearing that, like Chris might have mentioned, according to the Open Meetings Act, if you have to have a public hearing on, for example, adoption of the charter, you have to have it at a specific time. You got to have it at that time. All right. At the beginning of the meeting, like you did tonight, you adopt the agenda. Before you adopt that agenda, any member can make changes to that. I move we add this or subtract that or move this around and all that. Then you vote on the agenda as amended. And once it's voted on, it takes a 2/3 vote later to change it. Okay? That agenda will be binding. So if somebody comes in later and wants to add something, you can do that, but you got to vote on it. It takes 2/3 to do it. Okay, a word about decorum. Robert gets very specific about decorum, but I want to talk for a moment about civility. I made these presentations all over the state, and some of the places I talked to, they have a little bit of a difficulty with civility in their audiences. I can't imagine that, but it's the truth. And the higher you go in government, from the national to the state, let's say from local, county, state, national, the more we're lacking civility. Okay, just common civility. And it's more than just about being polite. It's about being able to disagree with each other. And face it, you guys are going to disagree with each other when it comes to should we have this provision in our charter or not, and how should this be worded? Should this be 3 people or 4 people? You're going to disagree. But disagree respectfully and try to find common ground to resolve those differences. Everybody's voice gets to be heard, and Roberts goes a long way to ensuring that happens, because everybody gets to talk. Nobody talks twice until everybody's talked once. And the chairman, by the way, or chairperson, has a big responsibility in being the gatekeeper of that communication and pointing out who talks now and who talks now. And you already spoke on this subject. Is there anybody else that wants to speak? That's the chairman, one of the chairman's main responsibilities. Make sure everybody's heard. Now here's the specifics that Roberts gets into about decorum. You have to be recognized before you speak, and that's simply a matter of, Mr. Chairman. And Chairman says, Slattery, and now I'm recognized, and I can make a motion, I can speak. Okay, if I have a question of the treasurer, I say, Mr. President, Mr. Chairman, Madam Chairman, whichever the case may be, would the treasurer tell us how much money's in the budget? So my question is to the treasurer, but I ask it through the chair. Okay. And it seems a little cumbersome, maybe, but it helps to maintain that formality, and it helps to keep the thing on a higher level, the discussion on a higher level. Confine your remarks to the merits of the pending question. That's, again, the chairman's responsibility. You're off topic. This is not germane, and that's a technical term that Roberts uses, germaneness, that you've heard before, I'm sure. Talk about the pending question. Don't talk about people's motives. You can debate and attack someone's motion, but or their reason. Don't talk about the reason for their doing something, but what they want to do. Don't get into the motives for somebody's motives. Assume everybody has good motives here. We're all working through this together. Okay. Oh, refrain from using familiar names. That seems a little stilted at first, right? But if you call each other Commissioner Boyd, Commissioner Bauer, Commissioner Jeffries, it elevates the discussion a little bit. I know you're friends. You probably know each other. You work together and all that. But your audience appreciates it. The people that are watching on television appreciate it. It's just more professional, and it helps keep things more civil. This is a civil discussion. So try to do that. Try to, Mr. Chairman, Madam Chairman, whatever, and Commissioner, use your titles when you can. So you'll get used to it and you'll like it. Okay. You don't talk about the things you did last month. You don't talk against it. You made decision as a group. Move on. The chairman has a lot of responsibility and a lot of authority, the chairperson. If you're talking and they need to interrupt you for some reason, yield to that interruption. It's one of the chair's prerogatives, I guess. But and you can talk amongst each other when you need to and everything, but don't disturb the assembly. Hey, I have a question. You don't do that. One of the pictures you didn't see up there was a guy standing here pointing at the chairman saying this, and the lawyer over here is going, oh, calm down, calm. You don't want to get there. So don't disturb the assembly. The chairman or chairperson is a gatekeeper, but there's a couple times when it's determined who gets to speak. Usually it's the first person that gets recognition. You have 3 people saying, Mr. Chairman. The chairman needs to decide whether was it Slattery or Bauer or Jeffries or whom. Unless Slattery made the motion, then Slattery gets to speak first to that motion. Unless Commissioner has already spoken first on that, then the chairman will say, Commissioner Jeffries already spoke on this. Is there anybody else that would like to speak? So that's what that's about. Now, I might make a motion just because I want to get it on the table. I may make a motion that we extend the mayor's term to 5 years because I just want to get it on the table and get it voted down. More likely is I want to see a 2-year term instead of 4 years, let's say. I think we should only have 2-year terms. So I'll make that motion fully expecting and knowing I'm going to vote against it. Okay? But I want to get it out there so we can all vote on it. I can vote against it, but I can't speak against it when I make a motion. Okay, I said don't speak a second time until everybody's had the right to speak or the opportunity to speak once. 2 10-minute speeches per motion per day. You probably want to be something less than that in your special rules. But, if you adopt Roberts and you have no other provision, that's what everybody can do. Okay, meat and potatoes. Motions, the big picture. Now, this is how business gets done according to Robert's rules, is through motions. And we're going to talk about 5 kinds of motions. Main motions, subsidiary motions, incidental motions, privileged motions, and motions that bring stuff back so you can change your mind. Okay, main motions are the things that introduce new business. When nothing else is pending, someone can make a main motion that says, Mr. Chairman, Madam Chairman, whichever, I move that we add section 3 to paragraph D. Oh, no. Testing, how's that? Thank you, Chris. Yeah, I got a little wild. Okay. Main motions, subsidiary motions. Yeah, I started flailing around, I didn't land on the floor. I think that's a good thing. That's better than last time. All right. Okay, new business is brought by main motions, and then usually a motion is not perfect. So secondary or subsidiary motions are the opportunity to change or perfect that motion. The most common one of those that we're going to talk about tonight is amendments, to amend the main motion. Incidental motions provide you a mean for questioning the procedure. For example, you might say, point of order. I think that last vote we take should have been a hand vote instead of a voice vote. Point of order. And then the chairman has to rule whether that point of order is well taken or not. Okay? Point of order. That's a incidental motion that lets me question procedure. Privileged motions are ones that are unrelated to the pending business, but they're urgent. I can't hear. All those people out in the hall are talking so loud, I can't hear a thing, So I rise to a point of privilege, and the chairman would say, what's your point of privilege? I'd say, I can't hear. And he'd say, would somebody, shut the door or take care of business or whatever. It could be something like it's too hot, it's too cold, it's too crowded, you can't hear is a perfect one. There's a fire in the wastebasket, anything that are urgent but unrelated to the pending business. Those are privileged motions, and they don't have to take a second. We'll talk about that in a minute. You don't have to get a second. You don't have to get anybody's permission to speak. You just stand up and say, I've got a privileged motion, and you state what it is. And then motions that bring things back, reconsider, rescind, lay on the table. All right, main motions. Oh, I want to make sure you get these goldenrod sheets. These are the famous goldenrod sheets that I got from Coco, and I don't know how many we need here. I brought more than I'll need for this group, but not really enough for the whole public necessarily, but we can get more. And I want to just briefly go through, show you what, point out a few things that are on these goldenrod sheets, because they refer to the 6 key characteristics of any motion, and that's on the inside table, the inside 2 tables. Ranking motions and non-ranking motions. And the paragraph at the top there talks about what is a ranking motion, what is a non-ranking motion. But what I want to point out is that this table from left to right shows whether a particular motion can interrupt the speaker. And some, like raising to a question of privilege, like there's a fire in the wastebasket, I can interrupt somebody that's speaking. Point of order, I can interrupt somebody that's speaking. Does the motion require a second? And you see that's the second column there. And you see all of the main motion and all the secondary motion and most of the privileged motions require a second. But a lot of them don't require a second. Okay? A lot of items are not debatable. For example, if I move to adjourn, we're not going to debate that. We're going to vote on it, yes or no. Okay, and across there, whether something is amendable. You know, again, if I move that we adjourn and we're discussing that, somebody else is not going to make an amendment. How do you make an amendment to a motion to adjourn? These make common sense, a lot of them. Okay, and then what the vote requirement is. M means it requires a majority, and the others say 2/3. It requires a 2/3 vote, and it's not 2/3 majority. It's called 2/3 vote. And the big picture on that is that as Chris pointed out, no, I don't think it was Chris that pointed out, it takes 2/3 vote to change something you've already voted on, like to rescind or appeal or repeal something. And it takes a 2/3 vote if you're going to take away anybody's privileges. Like I move we refer this to a committee. I bet that takes 2/3 vote. Oh, that doesn't. Oh, bad example. Okay. Previous question, where I say I want to stop debate and vote right now, that takes a 2/3 vote to approve that. And we'll talk about that one for a second, because that's very much abused, this call the question. You ever seen that at a meeting? Somebody says, question. I was at a meeting one time, and somebody said, call the question. And the guy leading the group didn't know really how to lead a group. And so he said, oh, okay. All those in favor, all those opposed. They voted immediately. That's not how it works. You've seen that. Okay. Okay, and then what vote is required, and can the motion be reconsidered? And there's a whole lot of information on this sheet, including those parliamentary principles that I talked about at the beginning, and then the back page is a typical meeting and some of the motions and some of the language you go through to make a motion. So we can get more copies of this one, Chris, if you need it for others. But okay. Oh, I just turned off my mic again. There. Okay. Okay, to handle a motion. Somebody makes a motion, and it gets recognized first. And we're going to go through these here as an example. Miller rises and says, Mr. Chairman. And the chairman says, the chair recognizes Mr. Miller, Council Member Miller. So then Miller makes his motion and sits down. And then somebody else stands up and says, second. That second doesn't require recognition. Making a motion requires recognition from the chair, but to make a second to that motion, you don't have to be recognized, you just say second. And maybe half the left half of the room is all going to call out second. You know, that all happens all the time, you know. Okay, moved by Smith, seconded by the whole west side of the state. Okay, okay, it's moved and seconded that, whatever the motion was. Is there any discussion? And then the maker gets to speak first on the motion. The maker of the motion gets to speak first, and then you debate it. It says rising, but typically in a small group, you raise your hand and be recognized. In a larger group, you would stand, and Roberts says you stand to be recognized. Okay, is there any other discussion? And that keeps going back and forth by those rules of decorum that we talked about a bit ago. And then you say the presider would take the vote. The question is on the motion to or that we do such and such. Now, I got to tell you, who's ever the chair of this group, you can't state the motion too often. You need to state that motion repeatedly so that everybody is very clear what you're voting on. You know, you don't want somebody later to go, oh man, I thought, I didn't. Yeah, you got to state that. So you'll see, and it's not so much in my examples, but you say the question is on the motion that, and if there's an amendment, the question is on the amendment to the motion that we do such and such, and we'll go through that example. And then the presider announces the result of the vote. The ayes have it, and the motion is adopted, or the nays have it. And you say ayes or nays. I was in a group, in fact, I'm still in a group. I still represent the Michigan MML on the Asset Management Council, and in some meetings, the chair there will say, all those in favor say aye. All those opposed, same sign. And I'm not sure exactly how to react to that. If I'm opposed, I'm supposed to say aye? And no, you say all those opposed say aye or yes. All those opposed say no or nay. Yes and no. Make it clear. Okay? And then you announce the result of that vote. Okay, the noes have it. And then you say what's going to happen because of, as a result of that vote. Okay, that's main motions. Secondary motions, and we're going to spend a little bit of time talking about amendments. And there's a few others that we'll go through quickly because those are all ones that you'll find very useful. To postpone something indefinitely means you're going to basically kill it. Okay? But most often you want to postpone something to a definite time, but most groups, a lot of groups, don't know about that, I guess, because they say, I'm going to table it. Well, we're going to talk about the difference between postponing indefinitely to a certain time and tabling. And then our friend previous question where we can just, end debate. All right, let's talk about an amendment. All that's up there. This was so dramatic, one line at a time when I had this all laid out. Okay, so let's follow this. See, we got a main motion on the floor. Somebody has moved, and it's been seconded, that we buy, and I'm using a city council example, because I deal I got a confession. I've never presented to a prospective or a newborn charter commission before. So cut me a little. I know. This is cool. I commend you in the city for doing that. It's a big step to amend your charter. I know. I went through it when I was mayor of Mount Morris. When one of the things our charter was like 40 years old, and it was a mess. So we did a whole charter commission thing, and we did some changes. Okay, we got rid of constables for one thing. Okay, so we have a motion that's been moved and seconded, and it's on the floor, and we're debating it, that we buy 12 decorative benches for downtown parks, and you're debating it, and the chair says, okay, great, is there any further discussion? And somebody starts thinking and says, I think we should, if we're going to buy benches, let's buy tables. So I move that we insert and tables after the word benches. And by the way, the big picture on this slide is that there's 3 ways to make an amendment: by inserting something, by striking out something, or by striking out something and inserting something else in its place. So those are the 3 things that this really is talking about. Okay, so then, we have a motion that we insert the word tables. Is there a second? Somebody seconds it. You're debating it back and forth. Okay, no more debate. They vote on that. Okay, that motion, that amendment passes, let's say. The amendment to insert the word and tables after the word benches passes. So now we're voting on a new amended motion that says that we buy 12 decorative tables and benches for downtown parks. Is there any other discussion? And they'll discuss it back and forth with the chairman following all those decorum rules that we talked about. And then somebody will say, but what about the other places, and not just downtown, not just the parks downtown, but what about the statue of the mayor? And what about the pool? And what about the duck pond? And that we want tables and benches there too. So let's strike out, I move that we strike out the word parks to make it more inclusive, inclusive. Okay, is there a second? So there's a second for that motion, and we debate it back and forth, and that motion gets approved, that we strike out the word parks. So all those in favor, and you vote on it. And then, so now the new amended motion you're voting on is that we buy 12 decorative benches and tables for downtown. Period. Okay? Oh, by the way, what would happen if that motion failed? If the motion to strike out parks, to amend by striking out parks failed? You go back to the one just above it that says that we buy 12 decorative benches and tables for downtown parks. You don't go all the way back to the original. You go back to the one that passed a moment ago. Okay, and then you're voting on that, you're talking about it back and forth. Is there any other discussion? And somebody says, as long as we're doing this, let's recognize our local heroes. Let's make these commemorative and not just decorative tables and benches. I move that we strike out decorative and insert commemorative. And so they go through that process again. Is there a second? And it's seconded, and it gets voted on. And if that's approved, now you're voting on that we buy 12 commemorative benches and tables for downtown. You see how that works? So there can be several different amendments, one at a time, each voted on one at a time before the pending main motion gets voted on. Each one required a second and is debated. And by the way, and we won't get into it tonight, but any of those amendments could also be amended. You could have secondary amendments, and it gets a little bit... Robert says you can't have a tertiary amendment because people's heads would explode. He didn't quite put it in those words, but it'd be too complicated. And they just all require a majority vote. And if any of those amendments fails, you're back to the motion that they tried to amend without the amendment. Okay? Okay. What about friendly amendments? You've all been in a meeting, I know I have, where somebody says, I've got this little amendment and it's not going to hurt anything. It's no big deal. I don't want to step on any toes. I want to make a friendly amendment that we change 12 to 14. And the leader will say, is that okay with the mover and the seconder that we do that? That's the part that's wrong. Friendly amendments are fine as long as everybody agrees. You can make it, strike out 12 benches and tables and make it 14 as long as everybody agrees. And how would you find out if everybody agrees? By saying, is there any objection to striking out 12 and making it 14? No. Okay, that's what we'll do. And you just do that by unanimous consent, it's called. Okay. But once the motion is made and stated by the chair, it doesn't belong to the mover and the seconder. It belongs to everybody. So friendly amendments are fine, but you just treat them like regular amendments. Okay, this is a good one. Postpone indefinitely. This gives you the opportunity to actually kill something. I've been in meetings, and you have too, where somebody doesn't want to vote on something. I move we table it. And then you table it at the next meeting. And you table it at the next meeting. And their idea is we're going to table it to death. Well, there's a way you can do it. Robert provides a way. You postpone something indefinitely. Because when is indefinitely? There's no time for it to come back. So it's effectively killed. Now, somebody could later put it on an agenda again and bring it back up and all that. But if you want to kill something, that's the way to do it. Postpone something indefinitely. But what if you just want to postpone, or maybe you have to postpone something just for a certain time? For example, these 12 decorative benches. Well, our program tonight is going to be a company that the Parks has found that does decorative benches and tables, and they're going to present us options and things. So I would move that we postpone the motion that we're talking about to buy 12 decorative tables and 14 decorative tables and benches for downtown, commemorative, for downtown, until after tonight's program. And if that gets a second and gets a majority vote, then we've postponed that motion until later on in the program, tonight's meeting. You can postpone it till later in the meeting, and you can postpone it to the next meeting. You can't postpone something until next month. Unless you meet monthly. You can't postpone it beyond the next meeting. Like you can't postpone something until next December. Okay, that would be tying the hands of your predecessors, the people that come after you, and you can't do that. All right, this is the one that gets people in trouble. That doesn't get them in trouble. They just misuse it to table or to lay on the table. This is when you want to do something temporarily, but you're going to take it up again at that meeting. For example, you're discussing buying those 14 commemorative benches and tables for downtown, and the governor walks in. So somebody might say, Mr. Chairman or Madam Chairman, I move that we table this until after we hear from our speaker. Okay? So think about it. You're actually essentially laying that on the table. You hear from the speaker. And notice, by the way, it's not amendable. It's not debatable. You just get a required majority vote. I move that we table it. Somebody else says, I second it. And you vote on it. And if it's approved, then it's tabled. It's laid on the table. Then the governor comes in and speaks. Now, here's the thing. And Coco will tell you this. Coco Seward will tell you this. If you lay something on the table, you really should clear the table before the end of the meeting. That's meant to be dealt with at that meeting. So later on in the meeting, someone would say, Mr. Chairman, I move this, that we take this from the table, and then you start debating it again right where you left off. Okay? If it was in the middle of an amendment, that's where you're at. If it was in the middle of a discussion of something, you just take it out. You don't have to make the motion again. You don't have to do anything. You just pick up right where you left off when you take something from the table at that same meeting. All right, previous question. This is the one that I mentioned earlier where somebody, and it's abused, and I feel sad for for a group that lets themselves get railroaded into this. Somebody back there the group is, no, not back there, that's the audience. Somebody up here is tired of talking of something. Audience, we love you, audience, but you're not part of the discussion, is what I'm saying. You've debated something back and forth, and whether to make it 12 or 14, and what color it should be, and all that, until somebody's tired of debating it, they just want to vote, and they say, I move the previous question. What that means is they want to stop debate and vote on whatever it is you're discussing. And the way that's properly done is somebody has to second that motion to call the previous question, or question, as it's frequently said. And if somebody seconds it, then the presiding officer takes a vote, a hand vote, not a voice vote, a hand vote, because it's got to be a two-thirds in order to adopt that motion to call the previous question. So let's say somebody called the previous question, somebody seconded it, the presiding officer said, okay, it's been called, the previous question has been called. All those in favor, raise your hand. And a bunch of you raise your hand. All those opposed, raise your hand, and it passes. That means the previous question is passed. Now, the next words out of the presiding officer's mouth is, all those in favor of the motion that we were discussing a minute ago about buying 14 commemorative benches and tables, all those in favor signify by saying aye. In other words, as soon as this previous question is adopted, the motion for the previous question is adopted, you immediately vote. No more debate, no more discussion, just vote. Okay? I mean, that was the whole point of previous question. But notice it requires somebody to be recognized, and it happens all the time. Somebody will say, question. Technically, that's not right. Technically, someone should say, Mr. Chairman, and Mr. Chairman should say Slattery, and Slattery would say, I call the previous question. You have to be recognized. But it happens all the time, and you really shouldn't do that. Okay? The presiding officer could call that a motion out of order and just continue, but they won't do that typically. So, because that probably if one person wants to call the question, probably so does half the other group, the rest of the group. All right. All right, so we talked about main motions, subsidiary motions, incidental motions, the ones that let you question procedure. This is the one that you call a point of order, but we're going to also briefly talk about division. This division is one where you can be used if you've taken a voice vote and it's not clear, either one of the members is not clear on the result of that vote, or the presiding officer is not clear on the result of that voice vote, which is a typical way of voting, right? A voice vote, all those in favor say aye. Somebody can call division, and what that means is we want to vote again by a more definitive way, which in this case would be raise your hand, for example. Okay, division. So you don't need a second. Anybody that's unclear has a right to be here, right to have the vote clear to them, so they can say division, or I call division. You can't debate it. You do anything. The chairman just after that says immediately conducts another vote by the next definitive, more definitive method. All right. And it says a rising vote, but in this parlance, and we don't really rise. We typically raise our hand. All right. Point of order. This is the one that you got some guy. Well, especially in a larger group, you got some guy in the back. Point of order. Because he wants to, show off what he knows all the time, perhaps, but is always pointing out a violation of the rules, or somehow he thinks he's been violated. Point of order. Now, you can interrupt the speaker. It's one of these items where anybody can interrupt the speaker and say, point of order. And it's the chairman's duty at that point to recognize that person and say, Commissioner Slattery, what is your point of order? And I will state my point of order. Mr. Chairman, I think that last vote should have been a hand vote, and we did it as a counted vote, for example. Or whatever other part of parliamentary procedure he thinks is being violated. Okay? So he points out his point of order, what he thinks is a violation. Then it's the chairman's duty at that point to make a ruling on that. Mr. Chairman, the commissioner's point is either well taken or it's not well taken. And those are terms you've heard lots all your life, right? Hey, your point's well taken. Well, it comes from parliamentary procedure. And what that means is, you make a valid point. I agree with you. Your point is well taken. We'll take that vote again by another method, or we'll do whatever it is you wanted corrected. Or the chairman can say, I rule that your point is not well taken. Which is a real polite way of just saying, no, I disagree, you're wrong, we're going to continue, we're going to move on. Okay? Your point's not well taken. You're wrong. Okay, so point of order. You can interrupt, you don't need a second, you can't be amended, it's decided by the chair. What if the chair is uncertain about whether that point of order is really valid or not? The chairman can say, what do you think, council or commission? And let you vote. And it takes a majority vote of the council to determine whether this person's point of order is well taken and should be addressed, or is not well taken, and we move on. So it can be, again, it's the group that's the ultimate authority, not the chairman. Should be the parliamentarian, but it's not. It's the group. Yeah, I know. I appreciate that. Okay, it's the group. I have a ruling from the parliamentarian. Okay. All right. Now here's the thing. If the chair makes a ruling on that and somebody disagrees, they can appeal it. They can say, I appeal from the decision of the chair. And then the chair asks the question, shall the decision, council, commission, shall the decision of the chair be sustained? In other words, I made a ruling, do you agree with me? Yes or no? And so, shall my decision be sustained? If he says yes, that sustains the vote of the chair or the ruling of the chair. If you say no, it overturns the ruling of the chair. All right, that's appeal. Okay. So there's other main we're just hitting on some of the motions that I figured would be useful in a small committee meeting. But privileged motions that about special matters that are unrelated but that are urgent. We talked about a question of privilege, like when the wastebasket's on fire, or it's too hot or too cold, or somebody you can't hear. That's a question of privilege. Call for the orders of the day. That means I think we're getting off track, and I want to get back to the agenda. As simple as that, and you can be interrupted. I'm getting off track here, but somebody can just say, Mr. Chairman, I call for the orders of the day. That means let's get back on our agenda, and the chairman generally will make a ruling, yeah, let's do that, and move on. And then adjourn, we all basically we wait for the whole meeting for adjourn, and there it is, okay. All right, call for the orders of the day, that means to get back on schedule. It doesn't require a second because it's one of those privileged motions. We talked about raising a question of privilege, like I can't hear, or it's too hot, or the wastebasket's on fire. I move to adjourn. I move that we adjourn. Cannot interrupt, but it happens all the time. Somebody will say, okay, I move we adjourn. But the real, actual, technical way is someone should say, Mr. Chairman, and Chairman should say, Commissioner Slattery, and Slattery say, I move we adjourn. And here's the thing. Using a technique we'll talk about in a minute, and I think I just kind of skipped over way earlier, consent, general consent. There's a word I'm missing. You don't even have to have a vote on adjourn or any other motion, really. I'll get to that in a second. You can just say, okay, is there any other business to come before us? Is there any objection that we adjourn? And if there is none, we adjourn. Same with like reading of the minutes. You don't have to read the minutes. The minutes have been distributed. Everybody's had, is there any changes to the minutes? And if there's no changes, okay, without objection, and you hear this in Congress all the time, right? Without objection, the minutes are approved. Without objection, we adjourn. So that's called unanimous consent. You should use it. It really saves a lot of time. Unanimous consent. And you can really use it for just about any motion that everybody understands that how they want to proceed. You can just say, is there any objection to, council could say, is there any objection to buying that red fire truck instead of the white fire truck? It's, it's a $700,000 purchase, but is there any objection? If there is, then you vote. If there isn't, well, you all voted. It's unanimous. Okay, unanimous consent. Lastly, motions that bring a question back. Allows you to change your mind. Even though you voted on something, it's not necessarily a done deal. Reconsider, rescind, and then we already talked about taking something from that you've tabled, taking it from the table. Reconsider and rescind are similar, but they're a bit different. Let's talk about each one. If you took a vote on something, like, for example, you voted on buying 14 commemorative tables and chairs for downtown, and then later on you got to thinking, what were we thinking, man? We can't afford that. We can buy 6 maybe. Somebody that voted on the prevailing side in that same meeting can make a motion to reconsider that earlier vote. Okay, I voted, Mr. Chairman, I voted that we buy 14 tables and chairs for downtown, but I moved that we reconsider that vote. The chairman would say, did you vote on the prevailing side? Or you know that, it's pretty clear. That means the winning side. If the motion you're voting on had been defeated, then somebody who voted no on that motion you want reconsidered would be on the prevailing side. You understand that? The prevailing side isn't the same as necessarily the yes side. It's the side that won the vote. So if the vote went down in flames, then somebody that voted to have it go down in flames can vote to reconsider it. Makes sense. You don't want somebody who voted on the other side to be able to reconsider it, because every time they lost a vote, they'd move to reconsider, right? So you have to vote on the prevailing side, and it has to be the same meeting. Now, this text says, or the next day. That really applies to like a convention a meeting that carries over from tonight till tomorrow morning. Hopefully, most of your meetings won't do that. So, all right. And then rescind is similar. You can either rescind or amend something that was previously adopted something that was adopted at a previous meeting. For example, if it was moved by, this is a city council example, but if it was moved that we demolish the building on the corner of 5th and Main because it's old, it's dilapidated, it's a fire trap, and it got approved and all that at a meeting, you can vote later to rescind that vote unless it's impossible to undo. That building's already been demolished. You can't undo that. And here's a catch on that. Even if you've taken action toward doing that, you can't rescind it. For example, if you've hired a contractor, for example, to do that demolition, hasn't started yet, won't start till next summer, but you can't rescind motions that you've taken action toward, as well as motions that are impossible to undo. Okay, so to rescind can be done at some other later previous meeting. It doesn't have to be done at this meeting like reconsider does. And you can either undo something or you can amend something that you previously voted on at a earlier meeting. Now there's 2 ways to do that. It takes a 2/3 vote when you don't give notice, but only a majority if you give notice to your group. At next meeting, we're going to discuss and vote on rescinding the motion to erect the statue of the mayor downtown. Okay? Now that's notice. You've been given notice. So then at the next meeting, when that motion to rescind comes up, it simply takes a majority vote. So you might have something that you're considering in your charter that you've made a decision on it. Next meeting, you're going to want to change it. You got to it's kind of a balancing thing. Do you want to give notice, thereby letting everybody know you're going to vote on this, and it takes a 2/3 vote to do it? Or do you want to kind of spring it and be able to do it by a simple majority? Do it whichever way is fair, right? So that's rescind. That's as it differs from reconsider, and that's a very useful tool because you can always change your mind. Taking from the table, we already talked about that. You've put something on the table because the governor walked in. Now the motion is I move to remove this motion that we were discussing from the table and take it up right where we left off. That's moving from the table. Clearing the table, as Coco would say. All right, we're going to talk about voting it'll only take a minute here, but there's several different ways of voting. One of the questions is frequently asked is, when do you vote on something by simple majority? When does it take a 2/3? Here's the rule of thumb. When you're changing something previously adopted, like rescind that we just talked about, then it takes a 2/3 vote. Or reconsider, right? Okay, rescind. Or when you're taking away or limiting members' rights, like you're going to refer this thing we've been discussing for 2 hours, we're getting nowhere. Let's refer it to the building committee. Let's refer it to a committee. You're taking away our rights to further debate it, sort of, so that takes a 2/3 vote. Okay? Calling the question takes a 2/3 vote because you're stopping debate. Roberts would never let one person in the back stand, question and then call that ending debate. Okay, so that's the general rule. Okay, voice vote's the most common. Before we get to voting, let's talk about abstentions. You're going to want to build something into your charter about abstentions. And when can council members abstain and when they can't abstain. Now, 2 state laws talk about conflict of interest, at least 2. Chris will probably come up with a dozen of them, but there's at least 2 state laws that talk about conflict of interest. One as it pertains to contracts, and another one that pertains to individuals, that says that you basically can't vote on things that you have a interest in not shared by your constituents. This is kind of more of a council. It's a council concept, but you're going to build it into the charter. Okay, and I've seen charters from all over the state that will say, that have a section on pecuniary interest or conflict of interest or what are some of the other things those might be called? But be aware of that. You're going to want to build conflict of interest and abstentions. When can council members abstain from voting? Because they're elected to vote. Right? I mean, council members are elected to vote. But you don't, and Roberts says no council member can be compelled from not voting. You know, in other words, you can't, according to Roberts, I should hold up this book. This is really the book. Yeah. Roberts says you can't stop people from voting. But state law says you can under certain conditions. And it's up to you building the charter to determine for your working with your municipal attorney, determine when those conditions prevail, where council members shouldn't vote, okay, or must not vote, okay. Conflict of interest. All right, just very quickly, voice vote is the most common ways is ayes and noes or yeses and noes. You always ask for the negative in your meetings when you're voting on something, even if it sounds unanimous in a voice vote. It's just Roberts says it's, you need to do it. Ask for the negative. All those in favor, everybody says yes. Any opposed? Crickets, okay? Always ask for the negative vote, even if it's obvious. Okay, a standing vote or a raising of hands vote is a normal method when it requires 2/3, because obviously you can't have a voice vote on something that requires a 2/3 vote. My ears are good, but I can't really necessarily tell when 2/3 of you voted yes or no. Okay. Any single member can order a hand vote after a voice vote by saying division. Okay. Because you want to make sure that everybody understands the vote and gets the vote that the group wants. All right. Moving on. Now, a show of hands is different. A show of hands is what we just talked about, or it can be a counted vote. Normally, now this is weird, I think. Roberts says when you order a show of hands vote or a rising vote, the chairman, without actually counting, determines the ayes and noes, yeses and noes, without actually counting. Well, when you got 9 members, it's kind of obvious, how many are which. But if someone's still in doubt, a member can, a majority vote of the body can require a counted vote. All those in favor, raise your hand and remain raised until counted. 1, 2, 3, 4. All those opposed? 1, 2, okay? Okay. That's a counted vote. Normally, a raising hand or a standing vote is not really counted. It's judged. All right. Getting down the home stretch here. Roll call vote. A lot of councils that I've talked to have in their charter that, or in their rules of procedure, that all votes are taken by roll call. all votes, even vote, and it gets kind of tedious, I think, sometimes when, I shouldn't editorialize, but, motion to adjourn, and take a roll call vote. And it's in the charter, they have to do that, But that's the way they want to do it, and if that's the way you want to do it, that's fine too. But you're going to want to include that in your charter, okay? When to have a roll call vote. What type? Others say you need a roll call vote when you're spending funds, or when you're adopting a resolution or an ordinance. It requires a roll call vote. That, in fact, your charter probably has language in it right now similar to that. So you might want to take a look at that. Okay. Even after you voted, you can change your vote if everybody lets you, by unanimous consent, in other words. Unanimous consent. That's the one I mentioned earlier. There's no objections. The chairman can just say, if there's no objections, such and such action will be taken. And that's your opportunity, members, to say, yeah, I object. We should vote on that. Then if one person wants to vote, you vote. Simple as that. But if there is no objection and you value your time, use unanimous consent quite a bit. That's what I like to do. All right, that's the last slide. Pop quiz. All right. The final authority regarding a rule, this is whether you've been paying attention or not, right? The final authority, whether a rule has been violated, is A, the group, the rules committee, the parliamentarian, or the chair. Yes.
D, the chair.
D, the chair. What? The chair. Somebody said the parliamentarian earlier. You said the chair. The answer is, and we talked about it way early, the answer is the final authority about whether a rule has been adopted is the group. The group. Because the chair will make a ruling, and then if somebody doesn't like that, they can appeal that, and then ultimately the group will take a vote on whether the rules have been followed or not. All right, just some last slide reminders. Robert's rules are useful, but in fact, Robert said in one of his early books, know all you can about Robert's rules, especially if you're the chairperson, but don't show off about them. And don't use them when it's not necessary. Don't try to impress people with your knowledge of Robert's rules. They don't like you for that. Keep it formal. Keep your discussions formal. Try to refer to each other by your titles and talk about the issues, not the personalities. Don't be more formal than necessary. And then always remember, treat your position and your constituents, the people that you're working for, your residents, with respect. And that's what I wanted to say about Robert's Rules and Parliamentary Procedure. Is there any question? I mean, I know there's a lot of stuff, and I hoped you'd ask questions as we went along, but... Chris, we have a question for you. No, I'll try.
No, this is really simple. You said to try to never use call the question.
Yeah.
But sometimes, honestly, it goes on, and the same thing is said over.
Oh, I don't think I meant to say never call the question.
Okay.
Because sometimes you are absolutely right. Things go on, and we've talked, and it goes, and even among a group, I mean, I'm not talking about public comment or anything, but among the group, any group, it goes on and on. It seems to go around and around and around. Somebody can say, but you don't just say call the question or question. You say, Mr. Chairman. The chairman or Madam Chairman recognizes me. Then I say, Madam Chairman, I call the question. And then if that gets seconded, the chairman or the presiding officer will say, okay, it's been moved and seconded to call the question. All those in favor say aye. Aye. All those opposed, no. Nobody says no. And okay, the question's been called. All those in favor of whatever motion we were discussing now, you take that a vote immediately.
Thank you.
Yes. No, that's important. Call the question has its place. It just gets abused. Just like table gets abused. That's one of somebody that thinks they know parliamentary procedure because they remember it from 5th grade, or, that nobody's going to object. They'll bully their way through and use things like that. All right, well, that's basically what I had. I thank you for your kind attention.
Thank you very much. Thank you for this. Chris Johnson is still here. Are there any questions that while we still have them before they head out, that any member wants to ask? Last opportunity. Seeing none. All right, thank you very much, Bob.
And you can always get a hold of the Michigan Municipal League and our inquiry service, or Chris or I through the league, if you have questions. Oh, yeah. You on another one of those? Yeah, I'm going to leave some of these for other members.
Okay.
I don't have enough for the general public right now,
Okay.
but I can leave some for your council members.
Oh, they don't need it.
Our council uses masons.
What?
Our city council uses masons.
Your council uses masons?
Yes.
Here, I'll
Yeah.
collect these yellow sheets.
I'm not proposing the charter commission use
I didn't know
masons.
that. I
Yeah.
didn't know any city councils use masons.
Yeah.
Wow, live and learn.
Yeah.
They're a larger legislative body, so that, well, that's cool. But I can leave some for, I can
That'd be
leave a
great.
few for others if you want, but don't
Um,
make copies of these because they are copyrighted, all right?
There's also an evaluation form.
Yes.
There, you can send them to
All right. All right. Thank you very much. Thank you. Okay. I just want to take the temperature. Do people feel like they need a short break or restroom or whatever? Or people can just sneak out as we're going along? Sounds like the majority wants to just continue on. All right. So we are to public comment, and I would propose that we limit public comment to 3 minutes per speaker if there's no objection by the commission. All right. So then we have, I know we have at least 3 people wishing to speak, so we will start with Jack Alexander, followed by Nicholas Sandy.
Just like to draw your attention to laughter.
Hang on a second. Can you pull the mic a little bit closer?
Just like to talk to.
Faith and Jack, is the
that
mic
better?
on the back? Faith and Jack, is that mic on? Oh, sounds like it. Okay.
Is it on now? Can you hear me now?
Not really. There we go.
Okay. I'd like to address to you about LAFTA. It was established in 1996. It was created separate from the city of Lansing government to run the city market, Lansing Center, and Jackson Field, which at that time was Oldsmobile Park. The city charter was not open at that time. I suggest that you bring the LAFTA under the umbrella of city government. It has been a total and complete failure. And I suggest, you can choose any name you would like, but I would suggest that you change the name to Entertainment and Public Facilities Department. And as I say, bring it under the umbrella of city government. The board should be done away with as well. That's been a complete failure. I've spoken to them for 15 years, and I might as well have been speaking to the wind. And all they do is just rubber stamp things. And I've been lied to. I've been stabbed in the back. The past CEO, he felt he was untouchable. He's left now. He's going to South Carolina. He felt that he was untouchable. He could do anything, say anything. I was belittled by him. And I feel if you bring it under the umbrella of the city government, you can eliminate a lot of these things I've just mentioned to you. And the only other thing I'd like to mention to you is that give the people the vote to vote whether or not they want to keep the strong mayor or have a city manager. Let the people vote on that, whether you get pros or cons or anything that you might get all during your process. Give them a chance to decide which one they want, strong mayor or city manager. Thank you.
Thank you, Mr. Alexander. Next is Nicholas Sandy and then Norma Bauer.
Okay, so I want to speak about one of my pet issues, and that is the idea of increasing the number of wards from the 4 we currently have, because having half at large is just an unsustainable way to run a city this size. I mean, it was nowhere near as bad as what Detroit was, where it was pretty much all at large before they changed it to having all but council members being in wards. Lansing needs to go further. The at-large stuff needs to be gotten rid of entirely. It is a plague on our city, and it just causes certain parts of the city to get more representation than they should. It started out with the north side having too much power, and now the south side has too much power. That's just an imbalance waiting to happen, and one side's going to get angry at the other. And that needs to change. We should also consider increasing the number of elected positions. I think the city attorney should be elected, I think the city treasurer should be elected, and I think the city assessor should be elected. Since they serve on the same commission with the city clerk on certain things, and the clerk is elected, I think those other positions should be elected. And no, as I've seen here from this presentation that went longer than it really should have, real talk, there should be time limits on that. In any case, it does not say anything about whether or not it's required for a city attorney to be appointed or elected. I'd say that it should be elected. Our state attorney general is elected. Why can't our city attorney be elected? That's just wrong. That just sounds wrong. And so we need to have more elected positions and not less. And we should also consider possibly a city manager as well as the strong mayor as working together to run the city. Something like how a president or a vice president work together. I've heard this whole argument and it just devolves into what's better, hard shell tacos, soft shell tacos. Why not both? I think a city manager and a strong mayor can work together. Maybe you can have a mayor run mostly elected mayor that can appoint some of the things and some of the people to the positions, and the city manager can run day-to-day operations of each department. That's one thing I think would be a really great thing. And just going one or the other would be a little too problematic. One is you have just a strong mayor, you just have an elected tyrant, and just a city manager, you have a non-elected tyrant who probably isn't required to live in the city. So I think having both would actually keep everything much more balanced. That's all I will need to say, and actually yield the rest of my time.
Thank you. Next, we have Norma Bauer and then Mike Lynn.
I'm Norma Bauer, and I concur with Mr. Zandy, and I think that we need 9 members of the city council, each representing neighborhood groups, because the people need a voice. And right now we don't have one because our city attorney says they're just advisory. And that takes away all their power. I think the city council needs to be the lawmaking body. And if all the members of the council represent a neighborhood group, then the people have a voice, and that's important. That's why we have a city charter revision. Finally, after all this time, people who represent LGBTQ, people who represent Latinas, people who represent black people, brown people, other marginalized people who meet the ALICE threshold. We need people who understand legal language. We need people who have a history. Jody Washington and Brian Jeffries, I think, understand what it's like to serve on this council, certainly Joan Bauer. And those are all important. So you're all important. I value you very much, and I thank you very much for your willingness to serve and represent all of Lansing. We need that. There were other things, and I got them in here, so let me see if I can find it. So it doesn't have to be a sweeping change. It doesn't have to go to a city manager right away. That would be very hard to accomplish within the time frames. I don't know how long it's going to take for Chris to arrange elections to approve or deny whatever you present the first time, and then the second time and third time. All of that is eating up time. We don't know how long that's going to take. It took a long time to get from January 29th, when the ballot was finalized, until May 7th. And there's a lot of reasons, and I know Chris is always completely in compliance with all the ethical rules. But I never want to forget that he's also the secretary of the local Democratic Party. So don't understand why he might feel a little compromised on that. No at-large positions. No ties if you got 9 members. Maybe there could be a vice mayor to take care of all ceremonial positions, and maybe Mr. Shore would resign as mayor so he could become the ceremonial mayor, because he's very good at kissing babies and hugging old ladies and all the things, presiding over funerals of prominent citizens and presiding over parades and festival of lights and so on. So I know you don't have to make sweeping changes to the whole charter, but please care about the people. That's my main thing. Everybody who lives here, because we want something better. That's why there is one of these. Thank you.
Thank you. Next is Mike Lynn.
You're welcome. We have a charter commission. Welcome all of you all. Really have high hopes for this group. Didn't in the beginning, but I'm gonna give everybody a start from zero spot. I will be here every day that you guys are here, unless I'm on a beach somewhere, but outside of that, I'll still probably try to come in. Just two-way communication to be great, if you guys can start that process. One of the big reasons I want to speak right now is not necessarily about anything I want to see, because we'll get to that, I'm sure, over 90 meetings. You'll see lots of us, but the city attorney not being involved. That was posed in a neighborhood meeting, that there was a question of whether or not you guys could get outside counsel or have the city attorney involved. From being in this room for the last 5 years, pretty much every day that they had anything going on, as well as in the committee meetings, we need to make sure that we keep our city attorney outside of this process. So that's an absolute, that the city attorney cannot be involved in this process whatsoever. Outside of that, remember that you all are just us. I hope that you all remember that. I see people get elected all the time and change up. I was at a table when Ryan Cabell asked, I believe it was Jody and Brian Jeffries, about if they were going to switch up when they got this seat. And they was like, well, why would I do that? Or whatever the case was. And he said, well, you don't know how anybody's going to act with a Cadillac until they get one. And I thought that was really important to state, because we don't know. And when people get up there, they tend to forget. So try not to be oppressive, you know what I mean? Try your best not to oppress the people that come up to this dais or this podium and speak. I've seen even with Robert's Rules of Order, which we know is just an oppressive way of handling a meeting. Just try your best to hear from us. I went to a DEI meeting that Commissioner Cowie was the chair of, and the first meeting was all about whether or not they was gonna allow us to speak and how long they was gonna allow us to speak. And it took like forever to talk about that. And then moving the meetings and all, this was ridiculous. And who showed up since? Nobody. You know what I mean? So like, just think about that aspect. How many people are really gonna show up to these things, and who cares? Half the people that showed up here to congratulate y'all walked out as soon as y'all sat down and start getting in business. So just remember that. When we show up, if it's just one person, 5 people, try to be as least oppressive as you possibly can. You remember some of you being on this side of the dais, talking to you all, trying to get your points across. Again, very excited about this. You guys have no idea. Some of you may worked really, really, really hard to get this open. And I think that I was more concerned about not who was going to be on it, any one individual, but just the group of you all recognizing you are citizens and coming to this to get some real change that's needed. First time in 40-some years, that means that something's going on in the city. This is not a situation you can sit in here and just status quo and get through 3 terms of this thing and go away with it. There's changes need to be made. So, no city attorney. Please get some outside counsel help. Thank you.
Thank you. And that was the last person that had filled out a registration form. Is there anyone else from the public who wishes to address the Charter Commission? Oh, Erica Lynn.
I didn't get a chance to fill out the form. Hello, Erica Lynn, lifelong Lansing resident, and I just want to congratulate everyone for being here. I am very excited for this throughout this entire process. I was also one of the people that worked extremely hard to get the charter open, because it is extremely important, not just to me, but to our community as a whole. I do want to echo some of the sentiments that have been said tonight. This would not have been passed through if our community as a whole did not believe that change needed to be made. So I think that that's really the foundation that I think we should be coming into this with. And it's not necessarily going in to say we're trying to make wide sweeping changes. I heard that adage talked about a lot. That's not necessarily it, but it's being intentional to go in with the mindset of knowing that we cannot remain and keep things the same, because we understand and know we're looking for evolution. We're looking for some growth. We're looking to come into 2024. I, had heard a quote that someone said, anything that was created more than a decade ago should be reviewed. Anything. And so for us, it's been a lot longer than a decade. There's been a lot of changes. There's been a lot of technology. There's been a lot of societal issues that have come up, and a lot of transformation and a lot of change that has come about just as a society as a whole. So definitely look at that. I also want to point out with the conversation about the city attorney, I want to elaborate that on a little bit, just because it's not just keep the city attorney out. It's just acknowledging the fact that it is an inherent conflict of interest. So when we have to understand that that is an inherent conflict of interest. And if we have the opportunity to have an external, completely objective, outside support in that nature, why would we not go for it? So I know there's a lot of conversation about cost and all of these things, and I just want to remind you that there's a lot of costs that we incur as a city on things that many of us don't necessarily believe are a priority. A lot of us, maybe even a lot of you, believe that that's a priority, so I don't think that price should be a deterrent on that. When it comes to the rules and all of that, I would say keep it light. I think we're all adults, and most of the people that are involved really just want to be able to have conversations with you all. 3 minutes never feels like enough. Sometimes it is. I would hope that you wouldn't shorten that or lessen that. But also remember that engagement is going to wane. I'd say that the largest engagement you'll get is probably the first few meetings. And then after that, you're going to get your regulars. So it won't be a situation where you have to be afraid of. I think sometimes the conversation is, well, what if, what if, what if? I think knowing that you have the opportunity to potentially change things as it goes down the line, if it becomes unsustainable, do that versus being less inclusive, less transparent, less oppressive, less, then do it up front, and then if we need to change it versus, the other way around. Otherwise, I can't wait to get to work with you all.
Thank you. Anyone else from the public wishing to address the commission? All right, seeing none, public comment is closed. And the next item on our agenda is to adopt the rules of procedure. Now, I have drafted some proposed rules of the procedure, and I believe they are in the back pocket of your folder. They are relatively brief, front and back side of one sheet of paper. If you wish, I can go through them with you briefly. Rule number 1 would just be that we follow the Open Meetings Act, Home Rule City Act, other pertinent laws, and follow Robert's rules where they do not conflict with these rules. Number 2 is that you shall elect a chair and vice chair. The chair at the beginning after this meeting will preside at all meetings, and the vice chair would preside in their absence. And if they're both absent, those members here would elect an acting chair. And that I will keep the journal of the proceedings, that I and my staff will provide administrative support for the commission, and I may designate someone to act in my absence. Number 3, that you'll adopt a schedule of regular meetings. Special meetings may be called by the chair or the vice chair, provided proper notice is given, and that meetings will be here in the Tony Benavides council chambers. However, if necessary and notice is given, that a meeting may be held in another place in the city. Rule number 4, 5 members is a quorum, and a quorum must be present for business to be conducted, and the affirmative votes of 5 shall be required for any motion other than procedural. And then again, vote shall be by voice vote unless the chair is in doubt and calls for a roll call vote, or any 2 members, which actually is in the Home Rule Cities Act, is that 1/5 can require a roll call vote. So the chair or any 2 members under these proposed rules could call for a roll call vote. Number 6, you're the The commission as a whole is the sole judge of qualifications of the members, and by 6 votes may remove a member for nonfeasance, malfeasance, misfeasance, as defined by law. And if there is a vacancy, no matter what the source of the vacancy, the Charter Commission will appoint to fill the vacancy, and it will take 5 members' votes to fill that vacancy. Rule number 6, public comment shall be 3 minutes per individual speaker unless an additional period of time is allowed by a majority vote of the members of the commission present. And then number 7, any amendment to these rules needs 1 week advance notice and will take a 2/3 vote. Now, these are fairly simple, straightforward rules. You know, if at a point you develop committees, there may be some need for additional rules on how committees are treated and such, but I feel like this is enough to get the commission going under a common understanding of how you'll operate together. I'm happy to answer questions or however you want to proceed.
Do you need a motion in order to have a discussion?
Under Robert's rules, technically, yes.
Then I so move.
Okay.
Second.
Thank you. It's been moved by Commissioner Boyd, seconded by Commissioner Adam Simon. And did you want to be recognized first on your motion? And then Commissioner Washington.
No, I'll pass, but I do have a question.
Okay. Commissioner Washington. Yes.
I don't have an issue with any of these things, but I would like to amend that we make public comment shall be limited to 5 minutes.
To 5 minutes? Okay. Is there a second to that amendment? Is there a second? Okay. Hearing no second. The amendment was on rule number 6 to limit public comment to 5 minutes per speaker. Okay. All right. Hearing no second. Okay. Any other debate? I'll second. Oh, you second? Okay. It's been moved and seconded to make the public comment for 5 minutes. Is there any discussion on that amendment? Okay.
I just had a question. If we want to move that to 5 minutes, why not stay consistent with City Council and the other boards that also have 3 minutes? We do have a provision in there to extend that period of time as we have built inside of there. So I just say that I'm just myself against of putting it for 5 minutes.
Commissioner Washington. Commissioner Washington.
Thank you. The reason being is 3 minutes is too short, and there is a reason it was taken down to 3 minutes, and it was to limit public comment. This is the people's constitution for their city, it's their charter, and there are some very important things that are going to be said with this charter. And frankly, I find 3 minutes to be too short a time for anybody to make substantial comment on what we're doing as far as the charter goes.
Commissioner Bauer. Commissioner Bauer.
If we adopted 5 minutes, would we still be able to have the prerogative of the chair if we had 50 people at a meeting, which would be wonderful for that kind of interest and input, to make it shorter?
That is not drafted at all, the ability to reduce that in these proposed rules?
Or could the body say, I move that tonight, because we have such a large group, that we limit? Would that be something we could do?
I would think,
Mr.
since
Chair.
that's not in the rules.
I think that would create a conflict because someone could say, well, the day that I came to this meeting, they decided to reduce my time limit. So we have to remain consistent.
Okay. Commissioner Boyd and then Commissioner Washington.
I just want to say that under the way this is written, the chair has the option of extending the period of time if there are comments that need to be made or are being made. And so I will support, as written, that it be 3 minutes with the prerogative that the chair could extend that period of time if it was necessary.
This would be my last comment on this, thank you. And The chair also has the prerogative of shortening the time if there are 50 people. It happens at council all the time, and it could be written in that particular bullet point. Like I said, this is so critically important that the public be involved, and I will leave it at that.
Okay, on the amendment to change the 3-minute limit to 5 minutes, all those in favor say aye.
Aye.
All those opposed?
Nay.
I'm unclear. Can we see hands, please? All those in favor, raise your hand. And all those opposed, raise your hand. Okay, the motion appears to fail. All right, so we have the rules as drafted originally. Is there further discussion?
Sir, I just have a question. You mentioned earlier that the council follows Mason's rules of orders, and yet you are recommending Robert's rules of orders. And with all due respect to the MML, I mean, my eyes were glazing over. There was so much to talk about with motions. So I'm wondering why you are making that recommendation. Thank you.
I am making that recommendation based on a couple of facts. Number one, Robert's Rules is more commonly known. This handy-dandy cheat sheet, there isn't one for Masons, even though there are really only a couple of differences. Masons, truthfully, is designed for larger bodies, such as state legislatures. Ingham County Board of Commissioners and City of Lansing are the only local bodies I'm aware of that use it. So I think it's just more well-known to Roberts. That was my rationale. Commissioner Boyd.
And just to clarify, under number 5, even though a quorum is 5 members to meet, that any action, if there's 5 members, always takes 5 votes.
Other than procedural motions, correct. Yes. Commissioner Boyd. I mean, down.
Thank you. So, I just want to make just clarification points so we're all on the same page here. So the procedures note that we meet here in these chambers, and I think we all had a lot of conversations leading up to this point that we wanted to meet people where they were, an accessibility issue, wherever that is. And so it does note in here that with a notice, and I guess I just want to be sure that we clarify what that means for this group. If we want to meet and have public forums somewhere else outside of this, and what does that mean for your office to attend those meetings and that sort of thing?
I can tell you it complicates our ability to be televised. From my experience, and this is why I wrote it this way, seeing council and other bodies over the years, when you meet at a different place, you actually lose people because they don't know where you are. When you meet in a consistent location, people can find you. Now, that's not to say there's never a role or a place or a time for a different kind of forum, but I think consistency is a benefit to the public. That's my opinion. It's your rules, so you can amend them. Commissioner Boyd.
I would just like to say that as I have contemplated this role, I have thought about a listening tour. I do think it's important that we hear from people, and we want to reach out as much as we can. And so I think that's important. But maybe we do a listening tour without action being taken at those meetings, because I think your point is well taken and well made, that people need to see us and know where things are and come here to be able to watch it on TV or whatever. And so I would suggest that maybe as we contemplate that, we contemplate a listening tour without action being taken, but that we can go out and hear people. And for the record, I went to a lot of candidate nights as part of this process, and I heard from a lot of candidates, but I heard from no people. I heard from no one. No one, none of the candidate meetings that I attended was the public giving an opportunity to tell us what they wanted. And so I think that's important that we hear it.
Commissioner Lopez.
Yes, I know that the regular meetings, I agree that it should be in one place so that people know. But I think as we work through this schedule, we might think of holding community meetings scattered, maybe in the 4 wards, so that we hear from the community, even though it might not be televised, but it'll be for the community. And I guess we can discuss that a little further, but that would be my suggestion so that we can have community input as such.
Further questions or debate? Seeing no further debate, all those in favor of the motion to adopt the rules, say aye.
Aye.
Any opposed? Motion carries. Okay. We are now to the point where we elect a chair. Are there any nominations for the office of chair? Commissioner Bauer.
I would like to nominate as our chair Commissioner Jeffries.
Do you accept the nomination?
I do.
Okay. Are there any other nominations for the position of chair? Any other nominations? Any other nominations? Okay, all those in favor of electing Brian Jeffries as chair, say aye.
Aye.
Any opposed? Okay. Congratulations. So please do.
Thank you, Clerk Swope. I just want to say thank you to everybody for their support. It's, for some folks, I've just met you during the campaign for the first time. Other folks up here, I've worked with you over the years, and I'm really looking forward to working with all of you. We've been given a very important task here. I can reflect on the time that I served on council, and I think this issue that we're dealing with is probably the most serious and impactful issue that I will have been involved with the city of Lansing. And I think coming together tonight, united in our votes, I think is a real positive step forward as we begin this process. And I also want to thank Clerk Swope for the work that he has done getting us to this point. And as it moves forward, this is a lot of additional work that you already have a full plate. You're going to be adding more. And so thank you for that. And again, I want to thank everybody for their support. I also want you to know finally that I am very accessible. If you have any concerns, questions, whenever, hopefully we're going to get new phone numbers and emails and all that stuff. Once we get that together, please at any time give me a call, reach out, and I'll try to assist you in any way that I can. Thank you.
Okay. All right, we are now to the election of a vice chair. Are there any nominations for the office of vice chair? Commissioner Cowie.
I would like to nominate Lori Simon as vice chair.
Okay. Commissioner Adam Simon, do you accept the nomination?
Yes.
Okay. Are there any other nominations? Any other nominations? Any other nominations? Okay, all those voting for Commissioner Adam Simon as vice chair, please say aye.
Aye.
And any opposed? Okay, congratulations.
Thank you.
Would you like
I
to?
would like to say something. I would like to thank you for your vote of confidence, and I'd like to thank the community members in the audience. My goal has always been to work collaboratively, respectfully, and be very transparent. So that's what I would expect from this commission. Thank you.
All right, thank you. All right, the next item, unfortunately, is not to the point where I had hoped it would be for this meeting. I had told you that I had hoped to bring 2 things to this meeting. One would be a tentative agreement, services agreement between this commission and the city attorney's office, and the other would be draft RFP for outside legal counsel. On the first one, after discussions with the city attorney, it was determined that that is not a recommended route because of there may not be inherent conflicts, but there are definitely potential conflicts that could come down the road, and that it just seemed to be a better route to go the outside legal counsel route. But unfortunately, I do not have a draft RFP. So we will work on getting that together. Commissioner Bauer.
I just wanted to comment, I got a call from Mr. Gil Wanger, and some of you know him. He was a city attorney many, many years ago here. He saw the chart, different, I don't know if he saw the 55 Charter Commission, but certainly the 78 Charter Commission. And he called to tell me, and he was the city attorney, and he recommended that this commission be sure we had a municipal attorney. He said at least 20 years of experience, that was his advice, but an outside skilled municipal attorney. And he said the other last Charter Commission didn't do that, not necessarily had just inside city attorney advice, but it took them much longer, and they made some decisions that they ended up having to reverse because they didn't have that kind of counsel. So I'm glad to hear our own city attorney department feels that that's also important. But I think it's good that we already had citizen input and from many years ago. Thanks.
Interesting to hear that name. He was also on the State Constitutional Convention. Yeah. Okay, so with that, obviously that will be unfinished business next time. And next we have our meeting schedule, your meeting schedule. Again, putting 9 people's schedules together is a challenge. We have proposed, I guess, well, Brian put this together primarily, right?
Well, yeah, but he talked to me about it.
Okay, if you could, that would be great. Okay, this is Emery from my office. If you want to come up to a mic so that the members of the public can hear you. There's a chair down there. They can sit at that chair down there. This is Emery, who will be doing a lot of work with the commission. So, Emery Drever, they've been with my staff since September of last year?
August. 9 months. And now I'm full-time because Charter Commission, hooray. Okay, so the schedule that we have proposed for you has optional proposed meeting dates on Tuesdays and Wednesdays. Just thinking about what y'all were available for this month, as well as generally it's easier to schedule these things early in the week. We avoided Mondays because that's when city council is. And we tried to make note of holidays and ethics board meetings as well, because those are meetings that the clerk's staff also oversees. The ethics board meetings, we don't oversee holidays, but we figured we shouldn't schedule meetings on holidays. We tried to go with twice a month thing per MML recommendations and other things that other bodies in the city do. So you'll see on Wednesdays, I believe it mirrors that 2nd and 4th of each month. On Tuesdays, I think it jumps around a little bit more just to try to avoid some potential conflicts that would exist from your administrative support, but this is just an example. You can do what you want with it.
Mr. Chair.
Commissioner Lopez.
Yes, so what time are you looking at? Meeting times?
So recognizing, and we didn't put a specific time on here, recognizing that I believe most or all of you have full-time day jobs, and the public participation probably is better in the evening. I would go toward a 5:30 or 6, but again, that is a decision that's yours to make.
So after 6, I guess, would be a good time. Could be 7 o'clock.
Could be.
7 o'clock. If
Hearing
it's at
6s and
7,
7s.
both days work for me. If it's
Okay.
earlier, then I'll have some conflicts.
Okay. Commissioner Cowan.
And I know we can switch with a week or 3 days notice, a week notice.
Yes, yeah. So we have to provide 18 hours of notice to the public for a change in meetings, a change to the regular meeting schedule. We have to notify the public within 3 days of that change. So,
Can I just make a motion for one of these then?
Sure, yes.
I'd just like to propose a motion to accept the Tuesday schedule, 6 o'clock.
Okay. It's been
I'd like
moved-
to support that.
Okay, it's been moved and seconded to use the proposed Tuesday meeting schedule at 6 o'clock in the evening for the listed dates. Is there any discussion? Commissioner Lopez.
I would like to propose a friendly amendment to that motion. 6 would be difficult. 6:30 is better on Tuesdays. So if you don't have any objections.
Is there any objection to amending the time to 6:30?
No
Is there any objection? There being no objection, 6:30 is adopted as an amendment to this by unanimous consent.
Oh,
Commissioner Adam Simon and then Commissioner. Oh, I didn't see. Okay.
Thank you, Chair Swope. My question with this is, so these are the proposed meeting dates, correct? And in several of these months, there's only one meeting. We have already lost 6 months in this process. We are going to lose 4 months at least at the end of this process. If you're going to only meet once a month, which is what's going to happen on Tuesdays quite frequently,
right,
that doesn't give us much working time. I won't be supporting the Tuesdays. I will move after this vote to have it Wednesday.
Commissioner Adams.
And I concur with Commissioner Washington. Looking at the schedule, we'd have more time to meet if we met on Wednesdays because there's lots of conflicts on Tuesdays.
Commissioner Boyd, you had your hand up earlier. Did you still want to speak? No.
I guess I do want to comment, but I guess I'd like to hear from the staff and hear the rest of the conversation.
Do you have a response to?
Well, let me just say.
Whom are you
asking?
Whatever. I will comment if I can.
Okay.
I was supportive of Tuesdays because I can look at all these and I can come to every single meeting and I don't have to ask for any excuses for not being here. I agree with you that meeting once a month could be problematic. So I guess I would like to see some sort of a schedule that, I mean, I like the Tuesdays because it doesn't interfere with my life. And I realize that that's not a priority for everybody. But I think meeting twice a month is important.
I think so too.
But I like Tuesdays. 6:30 is fine.
Okay. Emery?
Yeah, just as information, y'all can feel free to add anything to these. This was a simple 3:30 p.m. formula in an Excel sheet. If there's a month that you are like, oh, why don't we meet on this Tuesday? Like, y'all can absolutely feel free to add. We just wanted to give you something to go off of, but like, please feel free to amend it as necessary. I will not be offended. Do what works for y'all.
To be respectful of everyone's time, I would like to have a friendly amendment, propose a friendly amendment that we alternate Tuesday and Wednesday, but still meet twice a month.
Okay.
With that said, may I comment, or do I have to do
Well, we need
do I have to do a motion?
We're on that amendment, so is there a second for that
I'll
amendment?
wait, I'll wait.
Do you want to, is there a second for that amendment? It's been seconded by Commissioner Cowie. All right. Any debate on the amendment? I mean, you can go through and pick one by one the actual specific dates without just adopting a whole list. So, Commissioner Dowd.
I would just recommend, I was going to simply say that if we can go through certain weeks where there's holidays, that if we pick the Tuesdays and there's a holiday, let's go through and see if that Wednesday works for that week or vice versa. Just to get us to make sure that we've got the majority of months where we have 2 meetings minimum. I think sticking to the slate of either Tuesday or Wednesday is going to be very difficult across the board. So if there's a hybrid combination there, I don't know that it's exactly what's on the table yet of a Tuesday or Wednesday, but maybe week by week.
Commissioner Anderson.
Okay, so I just wanted to ask, I know you said earlier in the week is preferred, but is there like a specific reason we couldn't do like a Thursday if that worked better for everybody? No Thursday? Okay. Just a suggestion. Wednesdays are really tough for me, but like obviously this will be a priority, but I just want to make that known to the group.
Commissioner Boyd.
I would just like to say, if we stuck with Tuesdays, if you look at the proposed charter meetings on Tuesdays, and then you look at the column before on Tuesdays, you could certainly add in that extra meeting each month based on, like, if you could, if Wednesdays, if you can have a meeting on July 3rd, which is the eve of 4th of July, and I would assume a lot of people are gone, you could also have a meeting on Tuesday, July 2nd. You could have a meeting on September 3rd. You could, I mean, so I think it's easier to add in the meetings that are needed on a Tuesday, and that's all I'll say.
Okay. Commissioner Jeffries and then Commissioner Washington.
Thank you, Clerk Swope. I don't care if it's either Tuesday or Wednesday, but I think we should pick the one day to be the meeting day for all of our meetings. I think we just have to be consistent so the public can get, ingrained in how we do our business, when we do it, and I think it would be more accommodating for everybody if we did that. So I don't have a preference over Tuesday or Wednesday, but if we could, I think twice a month is the minimum we should do.
Commissioner Washington.
Thank you. I agree that it needs to be the same day. It's too confusing. I mean, we already said this about, if you don't have it, people forget to come. And my only thing, I don't care if it's Tuesday or Wednesday. They both work for me. It just looks like Tuesday is actually more problematic. However, if we're going to go with Tuesday, we're going to have 2 a month. They should not be week after week, because we don't have enough time if we have speakers or if we have things that we have to mull over. If you have it on the 16th and again on the 23rd of July, that's not really that good unless you're doing them all. But to squeeze them in each month at, one right behind the other just isn't really good for work, or if we need research done on something, a week is not always the best.
Okay, so I believe we're,
I just had a comment to the rest of my commissioners up here. Unfortunately, my regular job on 2nd and 4th Wednesdays, unless we did it at 7 o'clock, it would be very hard for me to make it here at that time. And I didn't think anyone wanted to do it at 7. So I could do it on Wednesdays at 7 if we started at 7 p.m. But that is pushing it pretty late.
okay, so I believe we're on the motion to alternate, right?
No.
So all those in favor of the motion that we amend it by alternating, say aye. All those opposed say nay.
Nay.
So we won't alternate. So I think we are currently on Tuesdays. So it looks like July, we may need to fill in July 2nd.
And September 3rd, I think.
And September 3rd.
And October 15th.
That would give us 3 in October, but that's fine.
Oh, I'm sorry. I forgot. I didn't see the 20th.
The 22nd. In my office, can staff this, and the ethics board, we can make that work. So August, we could go the 13th. Election day is really not possible. Sorry.
So would it make more sense in August to do the 13th and the 27th?
The 13th and the 27th?
Mm-hmm.
Instead of the 20th?
Yes.
Okay. That takes us to November. So we're scratching the 20th, yes, of August. I believe we're still 9/3 and 9/17.
Mr. Clerk, can we move that to 9/10, 9/24? Because the 27th of August is just a weekend.
Sure.
Thank you.
So 9/10.
9/10, strike 9/3, strike 9/17, strike 9/24. See, these are the kinds of times when Roberts doesn't really work. You just gotta go with the flow.
It's like 9, 10, and.
Yeah,
Yeah,
9:10
9.
and 9:24.
we read them all.
Once we get through December, I will read them all back to make sure we have it clear.
Scratch the first foot of the 8, October 10, 8, 10, 22.
I think so.
10:8, 10:22? That we'll deal with that. And do you want to do the same thing for November? 11/12 and 11/26 is probably Thanksgiving week. So do you want to do one meeting in November, or do you want to, so 11/12 and 11/19, 2 in a row?
But this is a Tuesday, that doesn't really conflict with Thanksgiving.
That's up to you. Do you want to do the 26th?
Yeah.
I'm okay with the 26th.
Tuesday of Thanksgiving week? Okay, 11/26.
And I think it'll actually be the Tuesday after Thanksgiving.
Will it? Okay.
I think so.
I looked at my calendar this year.
Because that would make.
28th.
Yeah, that would make.
Thanksgiving's
things
the 28th,
It's
so the 26th is-
third Thursday?
It's the fourth.
28th.
Fourth Thursday? Oh,
The 26th is the Tuesday before Thanksgiving.
Yes.
okay.
All right, and then what do you want to do in December?
Can I just ask?
Sure.
And November, are you going to keep it on the 19th, to the 19th to the 26th, or are you going to move it to the 12th?
The 12th and the 26th. And is what I heard. And then December, do you want to do the,
3rd and the 17th?
stay with 3rd and the 17th?
Yeah.
Okay. All right, so I have, I'm going to read through everything I have, and then let me know if you think I have something wrong. So I have June 4th, June 18th, July 2nd, July 16th, August 13th, August 27th, September 10th, September 24th, October 8th, October 22nd, November 12th, November 26th, December 3rd, and December 17th.
Great.
Okay? Somebody want to move that as an amendment?
So moved.
Thank you.
Support.
It's been moved and seconded. All those in favor of the amendment to the schedule, say aye.
Aye.
Any opposed? Okay, and then on the schedule as amended.
Just one point of note here, if we could. That puts us a month gap in July and August. We really will have like 4 weeks where we're not meeting. So we meet July 16th, we don't meet again until August 13th. So that could be okay. We're still at twice a month. I just want to make sure we're aware like that there's a big gap there.
Do you want to meet on July 30th?
If we're keeping on every 2 week, it kind of fills that gap. I just think
So are you moving
if we're
to
gone
add
for
July
4 weeks
30th?
from that could be a long period.
Yeah.
Okay, there's,
So yes, I guess I would move that we add July 30.
okay. It's been moved by Commissioner Dowd to add July 30. Is there a second?
Second.
By Anderson. Commissioner Anderson. All those in favor say aye.
Aye.
Any opposed? Okay. All right. Any other debate or amendments? Okay. Oh,
Is there a time, did we set a time? Is it 6:30?
6:30 was, it was, 6:30 is the
6:30.
motion as amended.
Okay, thank you.
Yes. All right, and we will put this in a clean list and get it to you all and to the public. All right, all those in favor of the motion say aye.
Aye.
Any opposed? Okay. That,
Mr. Clerk,
yes.
once the dates have been completed, will that be posted on our new charter website?
Yes, which, thank you. And by the way, just a couple of notes for you. You may have noticed that I was blind copying you when I was doing stuff because of the whole thing that he was talking about, reply all. So generally, whether you email each other or not, I mean, most of the stuff I was emailing you about was administrative type things, but just out of an abundance of caution so that you didn't inadvertently just reply all with some discussion toward a decision, I just made sure that that didn't happen. So just keep that in mind when you are emailing each other. And then we have set up a website. It's pretty bare right now. It does have the meeting schedule, so it's kind of through the city's website. The specific address is lansing.gov/1233/charter-commission. 1233. Charter-commission. Charter-commission. Let me see if it works without the 123. The 1233 is kind of a, yeah, it doesn't work without that. It's like the city's thing. There is a link to it from other places in the city page, so.
On the city page, it says Charter Commission.
Okay.
Click that.
Okay, great. There's a direct link from
Yeah.
lansing.mi.gov. Okay, that's easier. All right. With that, Commissioner Lopez.
Mr. Clerk, going back to the Charter Commission rules of procedure, on the third paragraph, the commission shall adopt a schedule of regular meetings, special meetings, may be called as necessary by the chair or the absence by the vice chair. I would like to add something here, maybe amend what we already passed, is to commit to at least 4 community meetings. Is this a special meetings called by the chair, but, you know,
I think that sounds like a future agenda topic. If,
well, I mean, you know, it can be, but I'm just saying that community needs to know that we're committed to going to the community and schedule or committing at least to 4 community meetings. That takes away, you know, a special meeting kind of vote, but knowing that we will be doing that.
So are you asking, I'm not sure what you're.
I'm saying that maybe I'm asking to amend the Charter Commission to include 4 community meetings.
Mr. Chair.
Specific meetings, not special meetings.
I hear what you're saying. When Ben added in July 30th, I thought, well, if we go a month, that might be a good time to do those community listening sessions that I talked about, where we would listen to people, hear from people, ask them questions, and get a sense of what they're looking for. And I thought, well, that month might be a good time to do it. I guess I hear what you're saying, but just like that, I have a whole list of questions that I was hoping we'd answer tonight. For example, you know, how do we plan to research the experiences of other communities? I mean, Mr. Johnson gave us a link to the MML where there are communities that have done charters, and we can look at what they've done. You know, how do we plan to identify what is not in the charter? How are we going to proceed so there's no duplication of effort, both in bothering people we want to hear from, and also, you know, the kind of information that we want. So I'm like thinking we need a committee of the whole meeting to hammer out some of these things, and I think what you're bringing up is something we need to talk about at length too. I think to just add and to amend these rules of procedures, I think it's just a bit premature, because I think we need to think through what we're going to do and when we're going to do it. And I think to your point, I think having listening sessions in each ward makes sense, but there are other people. I mean, there are stakeholders within the city, there are stakeholders outside the city, there's business, there's labor. I mean, how, and I don't have the answer, but how are we going to hear from those people? How are we going to do that?
If I may.
Can I try and, I appreciate this. So
can I
this is
just
kind of our
clarify?
organizational meeting. And now there's a chair and a vice chair, and you know, obviously there's more organizational things that need to happen because this is your body. And I think working with the chair and vice chair, we need to come up with an agenda. You know, I might suggest that these be sent to the chair as, or probably through me, since we don't have individual emails set up for you, as agenda topics that you would like to discuss, so we can use that in putting together the next agenda, so that we're coming with hopefully things in a more organized, in an organized fashion that you can all make decisions on.
Yeah, okay, let me clarify. I just want to say, I just wanted us to commit to at least 4 community meetings. I'm not saying when or where, but to make that commitment to the community.
Do you want to make that as just an independent motion that the commission?
I'll make that motion.
It doesn't need to be part of the rules. It can just be an independent policy motion.
Okay, so I make that motion.
Okay.
Second.
It's been moved and seconded.
Jasmine Camps. I mean, Commissioner Anderson.
Commissioner Anderson
Yeah.
got that second. Okay, it was a race.
Right.
All right. Any further discussion on that? All those in favor say aye.
Aye.
Any opposed? All right. And I don't believe there's any more business before the body. Sir?
Just kind of a housekeeping thing, and we've talked a little bit about this before, but, with the information that we're given tonight about FOIA and the Open Meetings Act and everything, are we going to be provided with computers and cell phones, other devices, or are we going to be expected to use our own? And that's a concern.
I do not have an answer to that. I have tried to get an answer, and we will work on that. And we are setting up emails for each of you, so that you will have a lansingmi.gov email address.
That's a good idea, because having my desktop hauled off by somebody.
It's not pretty, not pretty. And I guess it gets down to knowing whether and how each of you want a separate laptop or a city phone or something like that, so. Commissioner Washington.
Having been FOIA'd while I was on council, I do not want to hand over my personal phone. I do not want to hand over my personal computer. It's a real issue, and it really happens. So I and I did hear somebody say something about, don't worry about the cost, and I absolutely agree. This is the most important thing that's happened in our city in over 40 years. I don't think when you have a constitutional convention, you worry about, it's going to cost this. This is the most important thing we're doing. So I support what Commissioner Jeffries has said, because I've had it happen.
And I'm just going to follow it up with, if the answer now is we could figure that out, is when, and how do we make that formal request, or do we do that? I mean,
I am working with our IT department.
Okay. Like, do we, as a body, do we need to vote that yes, we're going to do this and that's what's happening, or? Okay, not our choice. Okay, great. I want to make sure that if it's moving forward, we got it.
I think the flavor of this discussion helps me.
We're happy to have a motion. We know all about motions.
Okay. No, that's fine. All right. Okay, it's been moved. We adjourn. Is there a second? All those in favor say aye.
Aye.
Any opposed? Okay, we are adjourned.
It's going to have to offload its containers, and then the ship may need to sail to another port, potentially Norfolk, for repairs. And if the ship's going to be there for a prolonged period of time, the ship's owners may arrange for the ship crew to be